Yes.
May it please, Your Lordship. Fresh admission, second application listed for tomorrow.
For what?
Admission.
Why?
A new case, madam. Some execution case is pending, madam. So there was a delay condonation which has been condoned. There was a application for delay condonation which was condoned on 28/4. So it can be listed.
Please, Your Lordship. To be file an IA for withdrawal of the deposited amount before the registry of the Honorable Court.
9th. 9th is over. 16th. 16th.
May I please, Your Lordship? I am praying for listing of a CRP in the stage of motion on tomorrow.
May it please, Your Lordship. I beg to mention an RSA for listing, Lordship. It was last listed on 10/4/24.
Why?
Lordship, for orders, Lordship, the low court records the call for and it has not been listed after that.
Check it out from the registry.
Yeah, please, Your Lordship. Your Lordship, this is MSc appeal, Lordship. Your Lordship, I'm praying for listing this case for Friday, Lordship, for orders, Lordship. Problems.
Lordship, a IA was fixed on 8 and that was refixed today, but somehow didn't came up in the list. There is somebody, a IA, it was fixed today, but somehow it didn't come up in the list. So it may be taken up at 2.
Today?
Today.
The matter is listed today.
No, not listed, but it was fixed today. There is some urgency, Lordship. Highly approach.
For admission, item 1 to 5 and connected item 23.
May I please, Lordship? May I please, Lordship? In this matter, Senior Government Counsel, Mr. Dinath will appear. He is lacks in code number 1, as because of item number 1 also going on in there in that case, Lordship. That's why after some time, Lordship.
I've asked them to file an affidavit.
He asked me some instruction has received by him,
You got instructions?
Lordship. After some time, Lordship. Obliged.
I mean.
Item 6.
My stenographer. Without correction. How is it possible? वही नौकरा के तो करने के ऑर्डर को रास्ता तो सब दिखे लास्ट तो साले की तो करेक्शन कोई बना नहीं रेस्पॉन्सिबल होने करने के इज हाईली कॉन्टेस्टेड मैटर यदि पेरेंट्स को करने पता है ये तो को है तो ऑर्डर पे निकल सकते हैं करेक्शन 이건 앞으로 놓고 이거 버려. 그다음에 뼈가 responsible over the can't be responsible. That's to be no corruption again. ये मेथड तो कहने के उल्लाई हो लिया था without the time. How is it possible? The inquiry to do. Let an inquiry be held by this official. तो करने नहीं तो कहने के order. It will be approved with it. So the inquiry will be there. Anything can be written here. Inquiry call for. Not an inquiry call for. Something which requires to be done by the register. How is it possible that to correction of fire for?
Item 6.
And appears on behalf of the petitioner as well as the respondents. This is the matter. Very call for.
For orders, item 8.
It to yellow connected 1 to 5.
Lordship, this is connected with. item
Have you
125.
taken steps to the dusty?
Lordship, I have been instructed that respondent number. Without fail to send me concerned affidavit, my lord, because I received the information yesterday only. Only respondent number 3 has received the notice. Respondent number 1 and 2 had refused to receive the notice.
So have you mentioned it in your affidavit?
No, lordship, I will file the affidavit because I. got
You
the
have not
instruction.
filed it. You're vacating the stay. It is seen. What had granted time to the petitioner to take steps by way of dusty on 2 earlier occasions. However, till date, no affidavit of service have been filed. Considering the above, least the matter of the 2 weeks. In the meantime, the interim order passed earlier on 19/2/2025 stands vacated.
Lordship, this is the similar item to item 1 to 5.
Not concerned. Matter be listed only upon completion of service upon the respondents.
Supplementary item 22.
Copy of this order be sent by the registry to the learned tribunal for due information. Yes, what is this?
Lordship, I make for response number one, Lordship, that was order for depositing 50% of the ordered amount. Order was passed, Lordship, on 19/6/24, Lordship.
Hey, I asuni. So here they have not deposited.
No, no.
You have filed an IA.
I for release of the deposition and release of the ordered amount. And thereafter, last occasion, I filed, in
Yes,
this case,
Lordship, we do have a check, Lordship. We will submit it to the registry, Lordship.
Who?
To the registry, Lordship. On last occasion, Lordship, we were asked to submit this check to the registry, Lordship.
Where is the check? Why haven't you deposited?
Sure.
When you are depositing?
Lordship,
Today?
we will deposit by today. By today itself, Lordship.
In main case to Leho. Your name?
P. Rabha on behalf of Ms. A. Gayan, Lordship.
There is no on behalf of.
Lordship.
Ms. P. Rava, the learned counsel appearing on behalf of the appellant submits that though by an order dated 7/4/2025, there was a direction to deposit the 50% of the awarded amount before the registry within 30 days. But on account of certain circumstances beyond the control, the said letter only arrived. The said check only arrived yesterday, and she would be duly submitting the said amount before the registry today. During the course of the hearing, the learned counsel has also shown before this court the check drawn in the name of the Registrar General, Guwahati High Court, Guwahati, amounting to an amount of rupees 7,39,000, bearing check number 800118, drawn on State Bank of India. Full stop. The counsel appearing on behalf of the appellant is directed to deposit the said check during the course of the day before the registry. Full stop. Liberty is given to the petitioner herein, the respondent herein, and the claimants herein. Who are the respondent numbers?
one,
The respondent number one, the claimant herein, who is the respondent number one, to file an application before the registry within by 7 days from today. Full stop. The registry shall, on such application being filed and upon proper verification and identification, proper identification and verification, and after taking into account, taking the bank details of the respondent number one, transfer the said amount to the bank, to the bank account of the respondent number one, whose details are provided.
Lordship, God bless.
Becomes ready. Madam, take this. You deposit it today. Yes, item 1 to 5. What?
I have received two instructions from the transport department and the SP Tejpur. And the instruction from the home department, I am waiting. Kindly give me some time. I'm in the process. I'll get the detailed instruction. And the instruction from the SP says, in that particular PS case, Lordship has directed us to obtain the instruction when the DAR, FAR and IAR were submitted in that case. They said that after investigation of the case, charge sheet has been submitted in that case and the DAR, FAR and IAR are not submitted separately.
Why?
Well,
Did you ask why?
the
And it is the mandate of the Supreme Court directions. Isn't it the mandate
that's
where it say the police are paragraph number 60 of my last
have-
order?
I have seen.
Isn't that the mandate? So
Lordship.
if that is the mandate, why the DA, FAR, all these things have not been submitted?
Separately, with the instruction of the home department, what is the mechanism? In fact, some instruction I have received, I need a detailed
The
instruction.
judgment in Gohar Mohammed makes it very
Makes
clear
it
how it
logical.
is to be done.
Lordship.
So
There is
therefore, I don't understand why this is being not done. And you see, what happens is, have you informed the insurance company? Now, this is a very pertinent question. Now, the moment the accident happens, if it is informed to the insurance company, they are also bound under 149. Now, they cannot raise these disputes of the delay in filing the claim petition if they were duly informed about the FAR.
on time.
Understood. In certain cases, you may not know what is the insurance, who is the insurance company, you may not know. That is another aspect.
Lordship.
But in a case where you have come to know that there is an insurance company involved, who is there, so information is to be given. The moment you give them the information, they are also bound as per 149.
True.
Now, if that is channelized, then things, the question of filing, delayed filing of claim petition makes no sense.
No sense. That's true.
Then what is to be done? There are another 3-4 cases also.
Today I have seen, I have the record of item number 1. I have seen the other cases.
You just take note of, in the other matters, whether any FIR has been filed.
Yes, 2 and 3.
FIR has been filed. So
Item
there
number
also
4,
you
FIR
give
filed.
him an
Item number 4. FIR laws, but not submitted because the letter filed.
I'm not on that. I'm only asking as to
FIR.
whether the FIR has been filed.
Filed.
Whether there was a name in the insurance company.
Lordship.
When an FIR is being filed,
FIR.
no. FIR mentions about a particular vehicle number.
Vehicle number.
Have you mentioned it? If the vehicle number is mentioned, now there's with the Parivahan's the application, you can find out who is the insurance company. There's no problem with that. Immediately you can find it out. Even nowadays with the Parivahan app, you can find out whether the pollution has been done or not. It has gone to that extent.
Yes.
So there seems to be nothing out there which stops either the insurance company or anybody from being anything to inform the insurance company. Now, once the insurance company is being informed, they are bound under 149 to settle it, to try to settle it. Now, if you don't inform them,
There'll be nodal officer for this purpose.
yes. No,
That is
well,
the-
it is to be informed to you, the insurance company. How you will have it informed, have you informed everybody who is your nodal officer? That I am not concerned.
Yes.
But have you informed, do you have a nodal officer for entire state of Assam or for each district?
Lordship, for for every companies, they have the nodal officer.
Only one.
Because some insurance companies, basically, their office is in Guwahati, Lordship. There are some micro offices, they don't have the legal officers. Only one legal officer is appointed for a state or for the regional lordship. They might be the nodal officer or anyone else might be the nodal officer for that region, my lord.
No, the information has to be given to that
Insurance
branch
company.
office where it has been registered,
No, that will
the
be
insurance has
transmitted-
been done,
Yes, that will be transmitted to that authorized officer. my lord.
isn't it?
That's true.
That is being done.
Policy has
Then
been
the
issued.
responsibility on them,
Policy.
whether they accept it, they don't accept. Thereupon the court will take its own course. Whether they file a claim petition or not. If they file a claim petition, they may not then have the liberty of filing any claim, separate claim petition after 166(3) period is over. But then also in certain circumstances, they can.
That's true. From the concerned branch such these things will move on. Things will start.
Now, I only want Mr. Nath to come up with a formalized thing from your home department as well as your transport department. As to how do you want to do it? Because anyway, the tribunal, these tribunals, the MACT tribunals have also some connection with the transport department, if I'm not wrong.
Transport department, my lord, their instruction, my lord, I have come across that they have some statutory, my lord, duty, and they said whenever they receive the last sentence, it says that that it is to be mentioned that verification of permit, fitness of vehicles, driving license, other vehicular documents are being carried out on receipt of request from the insurance companies and police authority and submit the verification report thereof. The other paragraphs in respect of the Gohar Muhammad, they said it is for the insurance company and the police authority. They are
No, the transport department also has a role as regards the permission.
True.
Now, if there is no permit out there, then they will inform the police officer.
They said,
And this will be duly intimated to the court
Lordship,
in the hour.
the police will inform.
Huh?
Police will inform. They
Police
said
will
that-
inform the court.
they said
So
that-
there is a direct link between the tribunal and the investigating officer.
Officer. The transport department says that the requisition will come either from police or from insurance company, then they will verify and they will provide the information, the report. That to that extent, they said, we have the mechanism, we will immediately the requisition we receive, we will inform the authority, whoever seeks the information. To that extent, they have given the reply. And so for the home department, ultimately the entire thing has to be implemented from the department, from the police authority. But some in the form of a guideline, it has been prepared, and that I have seen. But the written instruction, the detailed instruction, how the mechanism has been implemented, or what steps they have taken,
But
that
there has to
that
be
I
some notification issued by their home department upon all the police officers.
guidelines is, I have come across the guideline, but for implementation of that guideline, to what extent they have not issued the notification of the guideline, or what steps they have taken, that I have to.
Because the law has been settled.
Yes,
There's
law
no
is-
quarrel with that.
There is
Now it is the question of implementation.
implementation. That's. And this particular case, the information as I have received from the SP, that separately they have not done, they have filed the charge sheet and all. Possibly there is some gap, there is some lacking. Otherwise, they have not filed. So implementation part, we have to work on that.
Now they had to file all
File.
these things. They are required as per the Supreme Court judgment.
True. Very categorical, Lordship has noted.
In fact, as I have quoted those paragraphs, if
Madam.
you see my earlier order,
Yes,
as prescribed under the so-and-so, the Supreme Court said, the police officials as the registering authority are bound to take action in the event when an accident takes place and the information received by them. Further, it is seen that as per section rule the police is required to furnish the details of the victims regarding his here in the road accident. The flow chart of the scheme along with the form 2 is required to be furnished to them. The said flow chart and all other documents as specified in the rules must be either in vernacular language or in English and shall be there. Now, this is what is being said, because there was paragraph number 59. That was the issue which has been stated, that these police officers are not doing it. So therefore, the court in a exercise of 141 directs that you are to, and these are judgments which you are to follow.
Madam. True. And Lordship may give us some time, my lord, I'll apprise the entire city, but in fact, some guidelines are there. They have already quoted these things, and I have seen that FAR, DAR, all these things have been incorporated in the guideline. How far it is being implemented and what notification they have issued and what is the accountability? Ultimately, the thing is, my lord, accountability also.
This is the most pertinent thing. If,
Gotcha.
if you are not doing it, then in that regard, there might has to be some action being taken against these officials.
Well, at this stage, my lord, I would pray that, in fact, the Honorable Supreme Court's decision, there is no question of non-implementing.
Huh?
There is no question of non-implementing the direction of the Honorable Apex Court. Steps have been taken, my lord, and
Because what this court is now going to do is whether you have implemented the Supreme Court's direction. Nothing more than that.
True.
And if you have not done, then these claimants cannot be barred from they're entertaining their claim petition, whatever may be, whether 166(3) is there or not. Whether it is there or not, taking into account that these are things which have been mandated by Gohar Mohammed, and this is the law as per the newly amended the 2019 amendment. And if this is not being followed, therefore they cannot be taken away. The rights which is there cannot be taken away. Apart from that, these officers should also be put accountable for violating the Supreme Court's order, for which this court should not initiate proceedings against them.
that's followed that the strict implementation has to be there. From our side, my lord, we will do. In fact, steps have been taken, my lord. We'll apprise them.
Hmm?
Steps have been already taken. I'll apprise. I don't have the detailed instruction. but
And
now-
if the other matters, they will give the details.
Yes. my lord,
Other
I'll-
matters, you'll just get your information.
Yes.
We
I'll-
have
I'll-
it again on
I'll
a
collect the
particular
copy
date. On 3rd of June.
Lordship.
3rd of June, get your every details and file an affidavit
Yes.
as to what other actions have been taken. Okay.
Lordship.
Mr. Dina, the learned counsel appearing on the senior government advocate, appearing on behalf of the Home Department as well as the
5 and 6.
on behalf of the Home Department as well as the Transport Department of the Government of Assam, has submitted that in the present case, that is in CRPIO 111/2024, the final report, the charge sheet in respect to Tezpur PS case number 828/2022 have been duly submitted. Bearing on 29/9/2022. He, however, submits that the detailed accident report, the first accident report as well as the interim accident report have not yet been submitted as per his information. Full stop. This court have duly pointed out that the submission of these reports is not only mandatory in terms with the provisions of the Motor Vehicles Act 1988 as amended with effect from 1/4/2022, but also in view of the categorical direction so passed by the Supreme Court in the case of Gohar Mohammed versus Uttar Pradesh State Corporation, State Road Transport Corporation and others reported in 2023 4 SCC 381. The learned counsel, senior government advocate, had submitted that in that regard, the Home Department as well as the Transport Department are taking due steps for implementation of these. He further submitted, it is only that certain creases are required to be, he further submitted that it is only the question of fine tuning, which is to be required to be done by the Home as well as the Transport Department, which the said departments are doing it. Full stop. taking into account the above, this court, he further submits that he would place before this court by way of an affidavit on behalf of the said two departments as to what steps have been taken. First, this court further takes note of that along with the instant writ petition, there are other some other writ petitions, along with the instant writ application, there are other applications which have also been tagged along, wherein also police due FIRs have been filed after the accident. First, Mr. Dinath shall obtain instructions in respect to the said FIRs and also place before this court on the next date. First, this court further, in the meantime, directs the Superintendent of Police, Hunipur PS, to instruct the officer in charge of Tezpur PS to do the needful of submission of the first accident report, interim accident report, as well as the detailed accident report in respect to Tezpur PS case number 828/2022 before the concerned tribunal. Because now you can do it. There's nothing out there. You can do it. You submit from your side, you inform him. List the matter on 3rd of June 2025.
On some other day. On third, I will be out of station. Other day.
Am I concerned with you?
Lordship, you may prefer extending the interim.
The interim order passed in the present writ petition stands extended till the next date.
And Lordship, item number 4 and item number 23 as well.
In CRP numbers, number kita di dibo.
40/25
So and so.
and 257/24.
Have you taken steps? Service is
Lordship, he
complete.
has appeared in item number 4, Lordship. And item number 23, Mr. Topon Deori has appeared.
Okay. Service is complete. Only in item number 6 and 8.
Yes, Lordship, item
Eight,
number
that
8
is vacated.
that is back.
Mullah, look at in the last order, in paragraph 7, Lordship has said that this state government represented by the additional secretary. Lordship, kindly, in the last order, paragraph number 7, instead of additional secretary, kindly say additional chief secretary
Additional chief secretary.
in paragraph number 7.
एक उनके फाइल तो लुई बोल दे तो अपना इस वकीले जो ना अपनी फाइल ले घुसी किसे हाँ what is wrong
Paragraph number 7.
Before this court, however, finds it important, find it very opposite hearing to this court. Before part, in the order dated 23/4/2025, at paragraph number 7, this court had mentioned that the state of Assam is represented by the additional secretary Home Department, which should have been the additional, the state of Assam represented by the additional chief secretary,
Home and political.
Home and Political Department.
Lordship.
Full stop. The respondent number. Have you filed a fresh memo, parties?
My lord.
No.
No, my lord.
What is wrong? We vacate the interim order. Interim order vacated.
Lordship, I will be ready.
No,
Within
we vacate the
2
interim
days,
order.
Lord, within 2 days.
No. We will impose a cost of 50,000 upon you. Interim order, I have to vacate it. You have not done.
But within 2 days, Lord, I'll file it.
এনেকে লেখো, হ্যাঁ? This court further takes note of that in the order dated 23/4/2025, while including the state of Assam, it was shown as the state of Assam represented by the Additional Secretary Home Department, Government of Assam, as the respondent number 4. Full stop. There appears to be certain error as pointed out by Mr. D. Nath, the learned senior government advocate. Full stop. Accordingly, this court corrects the same. There seems to be some typographical error as have been pointed out by Mr. D. Nath, the learned senior government advocate. And accordingly, this court corrects the said order dated 23/4/2025. And the respondent number 4 shall be the state of Assam represented by the additional chief secretary, comma, Home and Political Department, Government of Assam. Full stop. It is also seen that that the petitioner did not file the memo of parties. Full stop. The petitioner, counsel for the petitioner is directed to file the fresh memo of parties within 3 days from today.
This direction is all applicable in all the cases.
No, only this, not on the other cases. In the other cases, he is only going to get the information. One point.
Question.
For hearing item 10.
Yes.
The appeal was admitted on 37/2008, my lord. Only two substantial question of law, my lord. Number one, whether the documents marked as exhibit 1, 2, and 3 being certified copies are admissible in evidence in the absence of any proof relating to conditions for admission of secondary evidence as enumerated under section 65 of the Evidence Act. More so, when those documents were marked as exhibit 1, 2, and 3 under objection. Whether number 2, whether the finding recorded by the learned court below that exhibit 1, 2, and 3 were marked without any objection by the defendant is perverse, being contrary to the evidence of PW3 plaintiff, namely Abdul Jalil.
So who exhibited exhibit 1, 2, and 3?
I was defending.
Plaintiff, who is the plaintiff? Which witness? PW3.
I was defending my.
No, madam, I am asking you. Who exhibited exhibit 1, 2, and 3?
Jalil, my lord.
That is not PW1. And when PW2 exhibited it, did you put it under objection or not? Where is that? As regard PW2, not PW3.
PW3 plaintiff, my lord, exhibited. This is.
PW1. PW1. Where is the plaint?
Yes.
Abdul Jalil is the plaintiff. Yes, read his evidence.
Yes, my lord. I am reading the evidence of PW that.
PW3
PW3 under from beginning or.
from beginning.
Yes.
Let us see how he exhibited.
এই গোচৰৰ মই বাদী হওঁ। বিবাদী মাটি মৈৰাবাৰী টাউনত পৰে। মৈৰাবাৰী মৌজা মৈৰাবাৰী টাউন কিষাণ 126 নম্বৰ ম্যাদী পট্টাৰ 7 নম্বৰ দাগত 3 কথা 8 লোচা মাটি বিবাদী মাটি। বিবাদী মাটি আগতে লক্ষীস্থান বেছফৰ মাটি আছিল। লক্ষীস্থান বেছফৰ জীৱিত থকা অৱস্থাত বিবাদী মাটি আহমদ আলী, মহম্মদ আলী আৰু তাহিৰ আলী ৰেজিষ্টাৰ দলিল যোগে কিনি লয়। দখল চমজি দখল কৰি আছিল। তেতিয়া 1958 চনত মাটি একচনা পট্টা আছিল। মাটি 1958 চনত কিনে। সেই সময়ত কিনা বেচা ৰেজিষ্টাৰ ডিড যোগে হৈছিল। তেওঁলোকে দখল কৰি থাকি বিবাদী মাটি 1978 চনত মোক ৰেজিষ্টাৰ ডিড যোগে বিক্ৰী কৰি দখল চমজি দিয়ে। সেই মাটি দখল চমজি লৈ চৰকাৰী ৰাজহ আদি পৰিশোধ কৰোঁ। তাত 90 ফুট দীঘল আৰু 29 ফুট দীঘল বহল এটা টিনৰ ঘৰ বনাওঁ। সেই ঘৰৰ 1980 চনৰ পৰা 1991 চনলৈ টুৰিং টকিজ ভাড়া লৈ আছিলোঁ। আচল দলিল হেৰাই যায়। মই দুয়োখন দলিলৰ চাৰ্টিফাইড কপি দাখিল কৰোঁ। মই দখল কৰি থকা অৱস্থাত নামজাৰি বিচাৰোঁ। একচনা হোৱা বাবে নামজাৰি হোৱা নাছিল। লক্ষীস্থান মৰিল। তাৰ একমাত্ৰ ল'ৰা গেনুৱা বাস্পৰ জীয়াই আছিল। লক্ষীস্থান বাস্পৰ গেনুৱা বাস্পৰৰ বাহিৰে অন্য সন্তান নাই। মই ম্যাদী প্ৰিমিয়াম আদায় কৰোঁ। মাটি ম্যাদী হয়। লক্ষীস্থান বাস্পৰৰ ল'ৰা গেনুৱা বাস্পৰে 1996 চনত এখন দলিল সম্পাদন কৰে। প্ৰদৰ্শক 1 হ'ল গেনুৱা বাস্পৰে দিয়া ৰেজিষ্টাৰ দলিল চাৰ্টিফাইড কপি আণ্ডাৰ অবজেকশ্যন। প্ৰদৰ্শক 2 হ'ল আহমদ আলী আৰু কাদিৰে মোৰ বৰাবৰে সম্পাদন কৰা দলিল চাৰ্টিফাইড কপি আণ্ডাৰ অবজেকশ্যন। প্ৰদৰ্শক 3 খন হ'ল পট্টাদাৰ লক্ষীস্থান বাস্পৰ সম্পাদন কৰা দলিলৰ চাৰ্টিফাইড কপি আণ্ডাৰ অবজেকশ্যন। প্ৰদৰ্শক 4 খন জমাবন্দী কপি। বিবাদী কেৰামত আলী এজন অন্য মানুহ। কেৰামত আলী মোৰ স্বত্ব দখলত গণ্ডগোল কৰে। লক্ষীস্থান বেছফৰ 1970 চনত মৃত্যু হয়। কেৰামতে লক্ষীস্থান বা গেনুৱাৰ পৰা কোনো কাগজ কৰা নাছিল। 1996 চনত মৃত কেৰামত আলী প্ৰহ্লাদ বেছফৰ আৰু আনন্দ বেছফৰৰ পৰা বিবাদী মাটি কিনা বুলি এখন দলিল উলিয়ায়। লক্ষীস্থান পুতেক বুলি কয়। লক্ষীস্থান পুতেক নহয়, আমি দেখা নাই। কেৰামতে প্ৰহ্লাদ আৰু আনন্দ নোহোৱাকৈ আৰু মোক আৰু গেনুৱা বাস্পৰ নোহোৱাকৈ নামজাৰি কৰায়। মই নামজাৰি এপিল কৰোঁ। মাটি জব্দ গোচৰ কৰোঁ। মোৰ এপিল নামানিলে মোক চিভিল কৰিব কয়, সেয়ে মই চিভিল গোচৰ কৰোঁ। মোৰ স্বত্ব সাব্যস্ত কৰি দখল স্থিৰত কৰিবলৈ কেৰামতে কৰা দলিলখন আইনত কাৰ্যকৰী নহবৰ বাবে প্ৰাৰ্থনা কৰোঁ। গোচৰ চলি থকা অৱস্থাত কেৰামতৰ মৃত্যু হয়। তেওঁৰ উত্তৰাধিকাৰীগণক পৰ্যভুক্ত কৰা হৈছে। মোৰ হকচত্বৰ মাটি হয়, মোক খৰচ সহ ডিক্ৰী দিব লাগে। প্ৰথমতে কিনা আহমদ, মহম্মদ আৰু তাহিৰৰ নামত মাটি একচনাৰ বাবে নামজাৰি হোৱা নাছিল। আহমদ আৰু মহম্মদৰ পৰা মই আৰু মোৰ ভাই হবিবুৰ ৰহমানে কিনিছো। 1978 চনত কিনো। নামজাৰি হোৱা নাই। মাটি একচনা আছিল। পিছত 1996 চনত বিবাদী মাটি গেনুৱা বাস্কৰৰ পৰা মোৰ নিজৰ নামত কিনো। মূল দলিলবিলাক হেৰাল। But it was not stated in the plain, my lord. মই আৰ্জিত লিখা নাই। 1996 চনৰ পৰা দলিল হেৰাল। এইটো সত্য নহয় যে 3খন দলিল জাল বাবে মূল দলিল আদালতত দাখিল কৰা নাই। গেনুৱা বাস্কৰ মৰা এবছৰমান হ'ল। মই দাখিল দিয়া জমাবন্দীত গেনুৱা বাস্কৰৰ নাম আছে, but it is wrong, my lord. এইটো সত্য নহয় যে গেনুৱা বাস্কৰৰ নাম বিবাদী পট্টাত উঠা নাই, যিহেতু গেনুৱা লক্ষ্মীচান্দ পুতেক নহয়। এইটো সত্য নহয় যে প্ৰহ্লাদ আৰু আনন্দহে লক্ষ্মীচান্দৰ পুতেক হয় আৰু তেওঁলোকৰ নাম নামজাৰি হয়। প্ৰহ্লাদ আৰু আনন্দৰ বিৰুদ্ধে হোৱা নামজাৰি এপিল কৰোঁ। কোনো কাগজ মই আদালতত দাখিল কৰা নাই। মই ম্যাদী কৰা প্ৰিমিয়াম ৰচিদ আদালতত দাখিল কৰা নাই। মই খাজনা দিয়া ৰচিদ আদালতত দাখিল কৰা নাই। জব্দ গোচৰ 23/3 তাৰিখ হয়। এইটো সত্য নহয় যে জব্দ গোচৰত মাটি কেৰামতে পায়। বিবাদী মাটি এটা মূৰত মোৰ ঘৰ আছে। বিবাদী মাটি খালী হৈ আছে। বিবাদী মাটিত নগাঁও কৃষ্ণ হল মালিকে চিনেমা চলায়। তেওঁৰ লগত মোৰ চুক্তি হয়। আদালতত দাখিল দিয়া নাই।
Who is 21, PW 1 and 2?
PW 1 and 2.
The judge who has written it in such a bad manner, handwriting, nobody can understand. What is wrong with these judges? These are court records, they should have been more careful. Let us see how the trial court deals with this. You must have argued that is right. Trial court judgment. Where is that? Page?
45. a suit for declaration of plaintiff right title and interest over a civil land and confirmation of possession and injunction, and also for declaration that the registered sale deed number 1266/96 executed on 5/10/96 at Morigaon sub-registration office is void and unenforceable in the eye of law. This suit was originally decreed by judgment and order dated 16/2/2002, passed by the learned civil judge senior division Morigaon in title suit number 21/99. The defendant preferred an appeal before the Honorable District Judge Morigaon, and the Honorable District Judge Morigaon by judgment and order dated 11/1/2005 in title appeal number 3/02 remanded the suit for proper adjudication after framing issues afresh. On 23/5/2006, the suit was transferred to this court as a result of enhancement of pecuniary jurisdiction of this court as per Honorable Guwahati High Court notification dated 22/2/2006. The plaintiff case is that the suit land measuring 3/8 lesser covered by DAG number 7 in periodic patta number 1 to 6 of Moirabari town, Kisam, under Moirabari Moja in the district of Morigaon as mentioned in the Schedule A of the plain, originally belonged to one Lokishan Basford, who sold the entire suit land while it was covered by annual patta number 28 and DAG number 279 to one.
Yes, come to page 56. That is why I'm saying. Kindly come. That is exhibit, plaintiff witness number 4 and 5 is relevant.
The plaintiff deposed,
Ah,
my lord. The
ah.
plaintiff deposed that he lost all the original sale deed of exhibit 1, exhibit 2, and exhibit 3. Hence, he submitted and exhibited the certified copy of the sale deed. In support of execution of sale deed, exhibit 1, 2, and 3, the plaintiff produced evidence of PW4, Lokeshwar Bora, and PW5, Sri Harendranath, PW4, Sri Lokeshwar Bora deposed that the learned
He is the
assistant
LD assistant.
LD assistant of sub-register officer, Nagaon, and as per direction of the court, he brought the volume of deed register of the year 1958 and 78. The deed number so and so was entitled at page 238 of the deed register volume, wherein it was written that the vendor Lokishan Basford executed the sale deed in favor of Ahmed Ali, Muhammad Ali, and Tahir Ali. And after relevant entry of the sale deed, the sub-registrar put his signature regarding authentication of the execution. Exhibit 4 is the volume number 1. So and so exhibit 4.1 is page number 238, where in the contents of exhibit 3 were entered. Exhibit 4.2 is the signature of the sub-registrar Nagaon. Exhibit 5 is the volume number so and so in which sale deed number so and so was entered in page number 270, 273, and 274. Exhibit 5.1, 5.2, and 5.3 are the relevant page. Exhibit 5.4 was the signature of sub-registrar Nagaon. PW5 Sri Harendranath Somua, learned LD assistant of sub-registrar office Morigaon, deposed that as per direction of the court, he bought the volume registered deed, the sale deed number so and so entered at page number so and so of volume number so and so. It appears from the said entry that the sale deed was executed by Genwa Basford in favor of Abdul Jalil. Exhibit 1 is the certified copy of the said sale deed. Exhibit 6 is the said volume. Exhibit 6.1, 6.2, 6.3 are the relevant entries of the said sale deed. PW5 deposed that the relevant entries of the said sale deed was made by him.
No. What is there? That is proved.
Yes, my lord, but
That is proved.
they did not prove the attesting witness and scribe also not prove, my lord. He only said that there is a sale deed, my lord. But another respectful submission, my lord, Genoa is not the legal heir of Lokishan.
I'm not going to look into that.
Yes, my,
This is the question of law.
yes, my
So
lord.
there is nothing else.
Put-
I am not going to
Jama
go
Bandi,
into,
my lord.
madam, these are the only two questions of law. First, 1 and 2 are actually, both of them are same. 1, 2, and 3 being certified copies are admissible in evidence in absence of any proof relating to the condition for admission of so-and-so under so-and-so and whether the findings recorded by so-and-so. Now the court, he has already given the proof that I have lost it. Then he has therefore brought in witness number 4, PW 4 and 5. And who produced the originals of the not the original, what are the entries out there, which is exhibit 4, 5, and 6. That means, Chalo.
My, head, this is the Jama Bandi, my lord. Your lordship may kindly see, my lord, Jama Bandi.
No. Zamani, I'm not looking. This is the question of law.
But he has, Denmark's name is not in the record, my lord. He-
Concurrent findings. Concurrent finding of fact. Chalo. Level. Heard Mr. T. Goswami, the learned counsel appearing on behalf of the petitioner appellant. None has appeared on behalf of the respondent on call. This is an appeal filed under section 100 of the Code of Civil Procedure 1908. For short, the code challenging the judgment and decree dated 17th of March 2008, passed by entitled appeal number 4/2007 by the Court of the Learned Civil Judge Morigao, hereinafter referred to as the Learned First Appellate Court, whereby the judgment and decree passed by the Learned Munsif number 1 Morigao, dated 9/7/2007, entitled suit number 34/06, was affirmed. Full stop. It is noticed and it is relevant to take note of that by an order dated 37/2008, the coordinate bench of this court had admitted the appeal by formulating two substantial questions of law, which reads as under. Full stop. Next. The question which arises in the present proceedings as to whether the two substantial questions of law which were formulated by this court in terms with section 100(4) of the code are involved in the instant appeal. Full stop. For asserting the same, this court finds it relevant to take note of. Full stop. For asserting the same, this court finds it relevant to take note of briefly the facts which led to the filing of the instant appeal, and more particularly, the filing of the instant appeal. Full stop. For the sake of convenience, the parties herein are referred to in the same status as they stood before the learned trial court. Full stop. The respondent herein the principal respondent herein as a plaintiff has instituted a suit being title suit number 34/06,
Original title suit number 17/96.
filed the suit being title suit number, what is that number?
Original number was 17/96. It was filed
Filed-
before the district judge Morigao. It was filed on 28/11/96. Then district, district judge transferred to civil judge senior division Morigao.
Instituted a suit being title suit number 17/1996 before the court of the district judge Morigao, which was later on
Transferred
renumbered as title suit number 21/99 and subsequently renumbered as title suit number 34/. 34/. 34/06. The said suit was initially filed against one Mohammad Keramat Ali and two others. Subsequently, during the pendency of the suit, as the was filed against Mohammad Keramat Ali and two others, as well as performer defendants, as well as some performer defendants. So subsequently, during the pendency of the suit, as Mohammad Keramat Ali expired, his legal representatives who were substituted. The legal representatives of Mohammad Keramat Ali as well as the are the appellants before this court.
Legally assured.
First, the case of the plaintiff, in short, is that the Schedule A land originally belonged to one late Lakhison Baspor, who died leaving the performer defendant number 1 as his sole legal heir. The said Lakhison Baspor during his lifetime sold the suit land to the performer defendant numbers 2, 3 and the father of the performer defendant number 4 by executing a registered sale deed bearing deed number 1148 of 1958 on 29/1/1958. At the time of the sale, the suit land was an annual patta land. The performer defendant number 2 and 3 and the father of the performer defendant number 4 were in possession of the said land. The performer defendant number 4, on his father's death, along with the performer defendant number 2, sold their shares, that is 2 kata of land, to the plaintiff. And the defendant number 5 by the plaintiff and the defendant number 5 by executing a registered sale deed number 928 of 1978 and delivered the possession of the land accordingly. Thereafter, the performer defendant number 5 handed over the share to the plaintiff, taking his share in another place. According to the plaintiff, the performer defendant number 3 sold his share to the plaintiff verbally. So it is claimed that the plaintiff is the absolute owner and possessor of the suit land since 1958. The plaintiff thereupon constructed a cinema hall and rented house over the suit land. As the suit land was an annual patta land, the plaintiff again purchased the land from the Genua Baspor via the sale deed number 867/96 dated 11/7/96. The case of the plaintiff is that the defendant number 1 obtained a forged sale deed bearing number 1266/96 from 2 unknown persons and having been trying to dispossess the plaintiff from the suit land. And it is under such circumstances the suit was filed. The defendants have jointly filed their written statement. After suit was filed. Huh?
On 28/11/96.
Suit was filed. Seeking a decree for confirmation of possession of the plaintiff with his right title and interest over the suit land described in Schedule A to the plaint, semicolon, a decree declaring that the registered sale deed number 1266/96 executed on 5/10/96, which is described in the Schedule B to the plaint as void, inoperative, and unenforceable in law, for issuance of a precept to the Circle Officer Lahoriga, directing him to cancel the mutation passed by him semicolon, for a decree of permanent injunction restraining the defendant to enter and dispossess the plaintiff from the suit land, etc. The defendant jointly filed the legal representatives of the defendants of the defendant number 1
Yes, my lord, and pro forma and defendant number 2 and 3.
and the defendant number 2 and 3 jointly filed their written statement wherein various preliminary objections were taken as regards the maintainability of the suit and also denying the contents of the suit land of the plaint. Full stop. The case of the defendant have been specifically mentioned in paragraph number 13 of their written statement, wherein it has been mentioned that the suit land originally belonged to one Lokhi Chand Baspor. Full stop. The said suit land was covered by an annual patta. Out of the said suit land, one Kukil Robidas was possessing 8 lessas of land towards the western side, and towards the eastern side of the Suddag, one Abdul Mujid was possessing about 2 kathas of land by constructing his dwelling house thereon. Prior to Abdul Mujid, the entire suit land was in possession of the original patadar, Lokhichand Baspor, and after his death, about long years ago, his 2 sons, Prahlad Baspor and Ananda Baspor, used to reside thereon, and the said Abdul Majid used to possess the said portion of land by taking the same from the said 2 legal heirs of Lakhishan Baspor. The said Abdul Majid came into possession of the said portion of the land with prior permission from the patta holders. The remaining portion of the suit land, measuring 1 katha, was left vacant. Only one roof is standing there, duly there, which is claimed by the plaintiff to be the alleged cinema hall. It was denied that there was any cinema hall standing over the suit land as alleged. It was also mentioned that while Abdul Majid was in possession of the suit land, the same was brought under the periodic patta by converting it from annual patta on payment of the requisite premium paid by the legal heirs of late Lokhishan Baspor. The said annual patta was converted into periodic one by an order dated 23/1996, and the land records were corrected on 25/9/1998. Subsequently, in favor of the principal defendant number 1, Keramat Ali, the land was mutated. was corrected in the name of the principal defendant of Keramat Ali on 9/12/1996. Huh? Is it Kulu? Was correct, and the land records was corrected on 25/90. Yes, madam, what is that? Page 83. Very difficult to understand what you are written.
Out of land, one Kukil Robida.
And the land records were corrected on 25/96. And the land records were corrected on 25/9/96. It was also mentioned that on 7/10/1996, the suit land was mutated in the name of Prahlad Baspor and Anand Baspor, both being the sons of the late deceased Lakhishan Baspor. But the deceased had no third son like Zenua Baspor as alleged by the plaintiff. It was also mentioned that the alleged Zenua Baspor, Zenua, Genua, was the son of some Monilal Baspor. And the said Zenua Baspor had no right, title, and interest over the suit land, and he had no saleable right to sell the suit land in favor of the plaintiff by executing any registered sale deed. It was also mentioned that the legal heirs of Lokhishan Baspor, after mutation of their names in respect to the suit land, sold the suit land to Keramat Ali, the original defendant number 1, by executing a registered sale deed number 1266/96 dated 5/10/96, and thus Keramat Ali lawfully acquired all right, title, and interest over the suit land as the principal defendant number 1 had already come into possession of the suit land from the said Abdul Majid prior to the execution of the said sale deed number 1266/96. It is seen that on the basis of the said pleadings, the learned trial court framed as many as 7 issues, which, being relevant, are reproduced herein under page 1415 of the citation. It is seen from the records that the said suit that in the said suit, the issues were framed on 2/2/2005 after the suit had gone into various other litigations, various forms of litigations. The said issues being relevant are reproduced herein under page 17, 18 of the same. আগৰ কেইটা নহয়, 17, 18. These are the
After remand, my lord.
after
district
remand.
judge.
The record reveals that on behalf of the plaintiff, 5 witnesses were examined. And and various documents were exhibited. And on behalf of the defendant, 9 witnesses were examined. And various documents were exhibited. At this stage, it is very pertinent to take note of, taking into account the substantial questions of laws which were formulated by the coordinate bench of this court, that Exhibit 1 was the certified copy of the registered sale deed number 867/1996. Exhibit 2 was the certified copy of the registered sale deed number 928/1996. And Exhibit 3 is the certified copy of the registered sale deed number 1148/1958. Exhibit 4 was the register volume number 6/1958. And Exhibit 4.1 was page number 238 of the volume number 6/1958, wherein the contents of the said deed, being deed number 1148/1958, were was noted down. Exhibit 4.2 was the signature of the sub-register. Exhibit 5 was the register volume number 3/1978. Is it so? Are you sure? Exhibit 5.
Four is Ramabandi, my lord. In
No,
the-
Exhibit 3.1 is Jamabandi. No. You see the judgment at page 51.
But just proof,
Maybe, but that was corrected. You see page 51 of the judgment of the trial court. That I've looked into. Was wrongly marked as exhibit 4, but later on re-exhibited marked as 3-1. Kindly see page 51, the last paragraph. Exhibit 5 is the volume number 3/1978, in which the sale deed number 928/1978. Is it 928 of 1978? Six, seven, one is 7, 8, 6, 7.
Exhibit 1 is 11/7.
1978. Exhibit 2. 928/1978. So, 3 is 1148 of 1950. Isn't it? Exhibit 5. Exhibit 4 is the exhibit 4. Exhibit 4 is the volume number 6/1958. Exhibit 41 is page number 238, wherein the contents of Exhibit 3 were entered. Exhibit 42 is the signature of the sub-register Nagaon. Full stop. Exhibit 5 is the volume number 3/1978, in which sale deed number 928/1978 bracket Exhibit 2 was entered in page number 270, 273 and 274. Full stop. Exhibit 5.1, 5.2 and 5.3 are the relevant page, and Exhibit 5.4 was the signature of the sub-register. Full stop. Exhibit 6 is the volume number 1396. Exhibit 6.1 and 6.2 and 6.3 are the relevant entries of the said sale deed, being sale deed number 867/1996, entered at pages 168 to 166 to 168. You did not prove your certified copy.
Proof, my lord.
Similarly,
Proof, my lord. Proof certified copy by scribe and attesting witnesses, my lord.
certified copy.
No, no, my lord. Original sale deed, my lord.
Are you sure? Exhibit core is the certified copy.
Exhibit
You did not prove yours. Or is the original?
Yes, my lord.
It is written wrongly. It was by statement. On behalf of the defendant, 9 witnesses were examined. And the defendant exhibited 4 documents. Exhibit 4 was the original of the sale deed, number 1266/96, dated 5/10/1996. Full stop. The learned trial court, by the judgment and decree dated 9/7/2007, decreed the suit in favor of the plaintiff. In doing so, the learned trial court, while deciding the issue number 2 and 4, that the plaintiff had right title and interest over the suit land through Genua Basfor, who was the only son of late Lokhisan Basfor, the original patadar of the suit land. The learned trial court also held that in view of the discussions, further also held that the sale deed number 1266/96 dated 5/10/96 was a forged one and liable to be cancelled, and therefore it was required for issuance, therefore a precept was required to be issued to the circle officer to correct the land records. The other issues were decided on the basis of the decision in respect to issue number 2 and 4. Being aggrieved, the appellants herein preferred an appeal before the learned court of the civil judge Morigam, which was registered and numbered as title appeal number 4/2007. The learned trial court, the learned first appellate court, after framing the 4 points for determination, came to a finding that the claim 4 points for determination. And decided the said appeal in favor of the plaintiffs, thereby dismissing the appeal. First, it is under such circumstances that the present appeal has been preferred. Ms. T. Goswami, the learned counsel appearing on behalf of the appellant, submitted that exhibit 1, 2, and 3, which were certified copy of the registered deeds of sale, were put under objection as would be apparent from a perusal of the evidence of the PW3, who was the plaintiff. And under such circumstances, the learned trial court, as well as the learned first appellate court, could not have relied upon the said exhibits as the mandate under Section 65 of the Indian Evidence Act 1872 was not fulfilled. She further submitted that both the substantial questions of law are interconnected. Inasmuch as the second substantial question of law pertains to as to whether there was perversity in the finding of the learned first appellate court in not taking into consideration that exhibits 1, 2, and 3 were put under objection. The learned counsel therefore submitted that when these exhibits are put under objection, the learned trial court, as well as the learned trial court, it was the duty of the learned trial court to decide as regards the admissibility of the said evidence at the time of passing of the judgment. Full stop. She therefore submitted that these very aspects were not taken into consideration by the learned trial court as well as the learned first appellate court, for which the two substantial questions of law which have been formulated are involved in the instant appeal. Any judgments? Any judgment? Okay, let me come back in 5 minutes. This court have duly taken note of the said submission and have perused the materials on record. From the said materials on record, it is seen that those certified copies of the registered deeds of sale were exhibited as Exhibit 1, 2, and 3. But the plaintiff have duly stated during the course of the proceedings in the trial that he had lost the originals of the deeds of sale and therefore wanted to adduce and therefore sought permission of the court to prove the same true. The PW4 and PW5. The evidence of PW4 and 5 have been duly taken note of by both the learned trial court as well as the learned first appellate court. Wherein, who have exhibited exhibits 4, 5, and 6. Which contains the relevant entries in the books maintained by the sub-registry pertaining to which contains the relevant entries in the books maintained by the sub-registry wherein the contents of exhibit 1, 2, and 3 were duly reduced into writing. Footstep. In view of the said, merely on the basis that there is an objection being raised to the admissibility of exhibit 1, 2, and 3 did not preclude the learned trial court as well as the learned first appellate court to decide the admissibility of exhibits 1, 2, and 3 along with exhibits 4, 5, and 6 and thereupon decree the suit in favor of the plaintiffs. Consequent, in view of the above of the observations, comma, the two substantial questions of law so formulated by this court by the order dated 30/7/2008 in the opinion of this court are not involved, for which the instant appeal stands dismissed with costs quantified at rupees 11,000. The registry shall return the records. এটা কিবা এটা দিবচোন, একটু হাত চাত ঘূৰাই দিব।
In the appellate court, my lord, cost was not given, my lord.
I have given.
No, my lord, it was not given.
Don't worry. He will go for execution. Let him go.
So not execution, but only permanent injunction, my lord. He right title interest and permanent injunction. He prayed for permanent injunction and right title and interest.
You won't go for execution, then he won't. But 11,000 is the cost.
Item 11.
Yes, this appeal was earlier heard by me.
Yes, it was a part heard, my lord. In time, it was discovered that there is no service report, my lord, and accordingly we were asked to serve by hand, and accordingly notices were served, and it was reported that a defendant number 1 died. Thereafter we filed substitution petition, etc., my lord. We were as stated by Dishonorable Court.
Service has been complete.
Yes, sir.
And for the respondent number 1.1, 1.2, 1.2.
You are the main defendant. Huh?
One.
You are appearing for whom?
And respondent number one, defendant number one.
Who, Sobita Chatterjee?
Defendant number one's legal
One.
aid.
Is the service complete?
Yes, sir.
My name has not been reflected in court list.
Hmm?
My name has not been reflected in court list.
Yes, what was the case, Mr. Chaudhary?
Well, the lordship formulated a substantial question of law
Hey, see,
on
specifically
9/5/2024, my lord. By order,
specifically limited.
whether the learned first appellate court was justified in reversing the judgment and decree passed by the learned trial court without considering section 13 of the specific relief of 1953 inasmuch as exhibit 2 was duly proved as has been held by the courts below. But the case, my lord, for specific performance of the agreement to sell, and this
When did you file the suit?
94.
94. And when was the oral agreement entered into between you and Binoy Krishna Banerjee?
81, my lord.
Huh?
81, my lord. 81,
1981.
1981.
That you pay this 5,000
Yes.
and this you pay him 2,178. He
Yes,
will execute. When did you pay the 2178?
my lord. That was on 24/1/1981. It was endorsed in the deed itself.
So you paid that.
Yes,
So he was supposed to execute the deed of sale,
deed of sale by the summer.
but he died in the year 1989.
89.
Then in that case, can you maintain the suit for specific performance?
Yes, my lord. Under Article 54, my lord. Their denial, my lord, from the date of denial, my lord.
Huh?
My lord, they refuse to execute the sale deed, my lord.
When?
That is in 94 itself, my lord.
No, 94 can't be. You entered into an agreement with your father, with the
No,
father of the appellant.
There is finding in the judgment, my lord.
We'll look into that. You entered into an agreement with the father of the defendant,
Defendant.
stating that you will pay him 2178. You will pay the mortgage or 2178, isn't it?
Yes, ma'am.
And mortgagee and remaining amount you will pay to the owner
Yes,
and he will execute the deed of sale.
yes, ma'am. Entire amount, these were paid, my lord.
Understood?
Yes, ma'am.
But the question is, this happened in 1981.
1981.
When did he refuse?
Refuse, my lord.
Let us see your plaint.
Yes, I have to.
Plaint.
Plaint at page 40, my lord. Start. I read from paragraph 2, my lord.
Page 40.
Page 42, my lord.
Amended plaint.
Then start from 40, paragraph 2, at page 40. Vinay Krishna Banerjee, since this was in an urgent need of money and contracted a loan of rupees 1,500 from pro forma defendant number 4, while alive and executed the mortgage deed in favor of the pro forma defendant number 4 by registered deed number 1972 of 4/2/1959. Sub-registered Guwahati, and there were mortgage 4 acres of land covered by that number 31 of number 155 village Toothpur, Moda Bordwar, which is described in the schedule G below of the plain in favor of the pro forma defend number 4 and delivered the possession of the state land in favor of the pro forma defend number 4. That according to the terms of the mortgage executed by Vinay Krishna in favor of pro forma defend number 4, the Vinay Krishna Banerjee was to repay the amount of loan within 3 years from the date of execution of the mortgage deed and interest at the rate of 12.5%.
When did you pay this? Paragraph 7?
Paragraph 7, madam.
When did you pay?
My lord, thereafter releasing, I paid my lord on 24/1/1981, my lord. It pays
Where?
paragraph 6, my lord.
No,
last year,
this is different.
delivered the possession.
No, possession has been delivered to you by the mortgagor,
Yes, my lord.
mortgagee.
Yes. And
I'm not that. When did you pay this amount of 2822 to the?
yes, paragraph 7,
When?
that after releasing the land described in the Schedule B of the plaintiff, the plaintiff paid 2,822 to Binoy Krishna Banerjee.
So there is no date mentioned.
No date mentioned, my lord.
So you paid that amount.
Yes, my
So
lord.
your right to get the sale deed executed starts from then.
My lord, under Article 54, my lord, when it is denied, my lord, there is execution of the sale is denied, my lord. Since there is no mention of the date, my lord, when to be, it is executed, my lord. Banerjee received a full consideration for the sale land, promised to execute the registered sale deed of the land described in the Schedule B in favor of the plaintiff. But in the meantime, Binoy Kumar became seriously ill, so he could not execute the sale deed, although he received the full consideration of the Schedule B land. That in the meantime, on the last part of 1981, the public of the locality raised some structure over 1 kotha, 11 lesser of land, which is described as Schedule A of the plaintiff. The plaintiff being afraid of interference on his right and possession over the land, approached Binoy Krishna to keep some permanent
Now,
evidence.
paragraph 9 says that you have been asking the plaintiff. Now, he
Yes.
died in 1989.
89.
So
Thereafter,
this document was executed in 1981.
81.
11/12/1981.
Yes.
What stopped you in the meantime to file the suit? When?
Malade, continuously, Malade, we were asking, Malade, I was asking.
Leaving behind the defendant as his legal heir, and during the time Binoy Krishna, the plaintiff verbally approached him on 83, 86 and just before his death in 1989.
Yes.
Then also he did not execute.
Did not
Then,
execute. Did
then
not
where is your limitation?
leaving
How do you take care of the
leaving
limitation?
the
How does the
plaintiff
first appellate
hardly
court,
approached the
first appellate court look into the
86
question of
just before
limitation?
the death of 1987, Malade. And
Let us
thereafter,
see
Malade,
what is the court, first appellate court look into, how the first appellate court appeal
Yes.
allows.
Malade, before that, Malade, regarding this, Malade, the trial court finding.
No, no, no. I
Our
was not
appellate court
entitled
only
to
on the
look
point,
into it.
only on the
See up
point.
at any time, so and so. on the chance of the heir apparent succeeding to an estate, the chance of the the question of limitation of performance of
This is a region starts from Malade, page 14, Malade.
right to it.
If appellate court reversal only on the point that Malade, the right of redemption that was not there, the and the defendant had the right of redemption of the proper mortgage property, and without that, Malade, the defendant number one, and apart from that, Malade, defendant number one had no right to execute the agreement to sell, Malade, and on the basis of that, this cannot be enforced. This was the finding of the appellate court, Malade. That finding is contrary to the section 13 of the specific report.
Is barred by limitation.
But the village court finding regarding and so far section 60 of the transfer of property. But
Yeah, maybe 60 or not, he did not raise. Is it a raising out there, anything? Did the other side raise that issue of 60?
trial court's finding that finding regarding limitation that has not been reversed by the appellate court. There is clear finding that it is within the limitation.
What are these documents compared with the original? 6690. Let us read the cross-examination of the plaintiff witness number one. What is the name of the plaintiff?
Bhuvan Mohan,
Let us see his cross-examination. Tell you, chief,
I'm sorry, I don't.
why, huh?
The cross-examination part, I entered into the case in the middle of, it was
Help it.
originally dealt by C.K. Sharma Guru, after his death,
No, the question is, here the
Well,
problem arises, is your limitation.
limitation, you'll also kindly see the finding of the trial court, issue number one,
Huh?
issue number one at page 31,
These are wrong.
trial court judgment.
That is wrong.
This
No, first of all, when you are, you have asked your here person, in 1981, you made the payment and thereafter nothing is there. Where is the question of this?
I was insisting,
limitation
I
goes
was,
on the date of it.
entire amount was paid, I was insisting, he was on ailing, then the dependent,
Where is the receipt that you have paid that amount?
the
What is the document?
that amount, in a letter,
Because he denies that document in his written statement. He says that it is a false document.
there is no evidence in the defendant side.
Hmm?
No, the evidence was reduced by the defendant. In this
Not necessary, but the fact that you
But-
have to show your utility
And,
limitation, isn't it the mandate under?
I
You want to come within the limitation, then there has to be specific statements.
am we allowed to read the issue number one, the finding of the trial court. Here it is clearly stated, I am reading, defendant averred in the written statement that the suit is barred by limitation. Though the burden lies on the defendant to substantiate this averment, but there is nothing in the case record. Article 54 of the Limitation Act prescribes the period of limitation of 3 years in respect of a suit for specific performance of contract. But this period has to be counted from the date fixed for performance of contract, and if no such date is fixed, the period of 3 years would commence to run when the notice of performance is refused. The plaintiff stated that he repeatedly requested the defendant to execute the sale deed in respect of the suit land. But the defendant number one, instead of executing the sale deed, mutated his name in the CITA, which was subsequently cancelled by the circle officer, Polasbari Bhai, the order dated 24/10/1994 in miscellaneous case number so and so. Exhibit 3 is the certified copy of the order of the circle officer. The conduct of the defendant number one appear refusal of performance of the contract. Having no alternative, the plaintiff instituted the suit, and there is no irregularity, and the suit is instituted within the period of limitation. Hence, the issue is decided in affirmative and in favor of the plaintiff. This issue.
Where is your averment that you noticed in your plaint? Isn't it the requirement of Order 7, Rule 6?
In paragraph 11, I have stated,
Yes, what is it?
that after the, at page 45,
Tell me, I'm ready.
that after the death of Binoy Krishna, the defendant number one, who is the son of Binoy Kumar Krishna, was requested by the plaintiff to execute the sale deed of B schedule land in 1988 January. And the defendant promised to do the same as soon as possible when he would be able to meet the other two defendants, defendant number 2 and 3. And in 1990 January and 1992 January also, the plaintiff approached the defendant and asked him to execute the sale deed of the Schedule B land. in favor of the plaintiff, but in spite of the repeated request of the plaintiff, the defendant has not executed the sale deed in favor of the plaintiff in respect of the land of the Schedule B. So the plaintiff is compelled to file the suit, and the plaintiff was always ready and willing to do his part, but the defendant is always refusing to do his part of this contract, and the plaintiff is still ready to do his part. This much of statement I have.
Refused when?
My lord.
You see, the learned trial court relies upon some order of 1994,
Yes,
which is
19.
not even your case in your plaint.
My lord,
That is not your case in your plaint.
continuously he was approached, defendant number one.
You should know. Can you keep on approaching, and you will deny that value your statement. Therefore, I wanted to see where have you mentioned whether in the cross, and you don't have it anything. No case. We should dismiss.
My lord, regarding Article 54, my lord,
54 is what?
54, my lord, there is
In
no-
1981 was the date on
yes,
which
sir.
it was required to be done.
1981 was the date.
Thereupon, he did not do it.
My lord, hereafter, we were pursuing, my lord.
Pursuing for 9 years. Are you?
My lord, he was buying buying time, my lord.
He was, so you knew that he was buying time. 81, he did not. You approached the father many times. Then also nothing has happened. Then, what is the finding as regards the proof, as regards that particular document?
Which one, my lord?
That document on which you are saying that the defendant has anything to do? Exhibit 1. Execution of the registered mortgage deed, execution 1 in favor of so and so. Then what is exhibit 2? The court had looked into.
Exhibit 2 is the endorsement.
Exhibit 1. Yeah, cannot be allowed, so and so. How does these people prove the signature of this person concerned, the defendant number 1? Okay.
Defendant number 1, my lord.
How is it his signature being proved? And the other two defendants are very much there. The other two defendants, their land are there. They are not party to this agreement.
That is why the section 13 of the specific relief act.
What does it say? Section 13 comes in
13
play in a sense that if a person enters into an agreement on a
Yes.
particular date,
Yes.
when he had no right, subsequently, if he gets a right out there, specific performance can be made against him.
Well, my case is that the defend number one was to, after receiving the entire amount, he was to execute the sale deed. But he could not because he was at a bedridden stage, Malon. Then he asked the defend number one, his son. Defend number one is the son of the predecessor interest of the defend number one who was supposed to sell this sell deed, Malon.
How?
Malad,
How can he alone sell it?
Malad, he was asked that on behalf of him is agreement to sell that should be executed.
Where is your agreement for sale?
Agreement for sale is exhibit one, Malad.
Exhibit 1 is not agreement for sale.
Exhibit
Huh?
exhibit two, right?
Exhibit 2.
Exhibit two.
Exhibit 1 is some photocopy document.
Yes, exhibit two, Malad. That it was executed on 11/12/1981. And on his father's behalf, it was executed, Malad.
Hmm?
As per the direction of the father, it was executed.
Whatever may be.
And it was not,
Exhibit 1 is this.
It was not denied also.
Exhibit 1 is what? This is an unstamped document, nothing is there. 11/12/1981. Isn't it?
suitably one. Pro forma defendant number 4 accepted the mortgage amount of the and.
What
the
is
details
exhibit 2?
Exhibit two is the document, Malad, the agreement to sell. Malad. That was
Exhibit 1 is the,
Exhibit one is, Malad,
it is between one,
regarding receipt of the amount by the mortgage.
no, exhibit 1 is Barabar in Sri Juta Hantiram Kolita. Who is he?
Antiram Kolita was the mortgagee, Malad.
Mortgage. So this is that particular document. Absolutely, the question does not arise. It's barred by limitation. 95. Hello, we dismiss you.
Malad, it is not barred by limitation, Malad.
It is
Malad,
barred by
if the
limitation.
conduct of the defendant, Malad.
There is no conduct of the defendant.
Contact of Malad, he was Malad every time Malad while I approached Malad, then he took plea that
Mhm.
he
Where is
discussed with the defendant number 2 and
There is
3.
nothing out
and-
there to do.
After discussion of the defendant number 2 and 3, that will be executed. And thereafter he approached the civil court. Civil court also dismissed his suit, Malad, regarding that. And yeah, and he applied for mutation of his name. And on that basis, my lord, by his conduct, it is presumed that he has refused to execute the sale deed, my lord. That is why we approach the civil court, my lord. That is our clear explanation, my lord, in our claim. State court also has not dismissed the suit on this ground, my lord, only because of the right of redemption, my lord, that with that plea, my lord, it was dismissed. Appeal was allowed.
There has to, anyway, there has to be a tripartite agreement. Where is that? Between that, there's a novation of a contract to the effect that, okay, I ask the plaintiff to make the payment on my behalf. How did he hand over the possession?
That was an oral contract in between the fiduciary interest of the defendant number one.
Is it permissible?
And the plaintiff.
Is it permissible?
Malad, he requested to pay the amount of the mortgagee, Malad. And accordingly, the amount was paid.
No, because you see, this is a very important thing. The deed on which the mortgage deed was there,
Yes, ma'am.
that was a certified, the registered document.
Registered document.
So if it is a registered document, how do you do it?
Only
By
on
way
the,
of an orally?
only on the deed, Malad, it was endorsed that the amount of due that has been received by me and he.
How is it possible? Where he is not a party there?
Who, Malad?
That person
He
is
is
not,
party, Malad. He is the defendant number 4 here in this case. Mortgagee.
not on that. Is when he handed over the possession,
Yes,
when he took the money by the defendant, performer defendant number 4,
yes,
had taken the money from you
yes.
and handed you the possession, did that person concerned, the father of the defendant, did he sign the document?
He did not sign it.
Then what is this? Somebody, if we go by what you are saying, if we go by that, because there is no other evidence.
Evidence is there, my lord, regarding that the amount was paid, my lord, that evidence is there, my lord.
You paid the money.
Yes.
Let us take an example of a very simple example. A and B enters into an agreement.
I have understood, my lord. I have understood, my lord. There is.
Somebody else goes out there. If we accept what proposition is following out here, yes, that person may continue to have a right over it. Taking into account that there is no agreement, there has to be a tripartite.
Only that much of endorsement is there on the deed of mortgage itself, that I received the amount and so has been put into possession.
So
That is, and in evidence also, they have not controverted. In cross
you
examination.
don't know what is there in the evidence. You just say,
I may be allowed to see the report. from
is it,
the-
2 o'clock we'll look
Yes,
into it.
yes.
But I think on the round of limitation, we should dispute.
No, limitation, my lord, already.
On
we
this,
have explained, my lord.
on 60, substantial question number law on 60, I'm dismissing it and add and overlap it with 54. The appeal is getting dismissed. That is what it is.
But your
Only
lordship
how do
formulated,
I overlap it?
lordship formulated on that day, they say.
13 would not come into the picture, taking into account that person did not have the right. And apart from that, this is part of the
Did
limitation.
not have the right on that day, my lord, but at the.
Because here, you see, once the time starts to run, the time started to run from 1981. So once the time has started to run, it doesn't stop unless by way of some document to that effect, it will be a fresh limitation which may happen.
There cannot be a document, my lord, because the person was at a bedridden stage, and at that stage, he instructed his sons, my lord. And son was taking time, my
That
lord.
means you are saying that a person who is bedridden from 1981.
Yes, my lord, 81 to 87, my lord. That is why he asked
81 to 87?
that is why he asked his son to.
See the evidence. We'll
Yes,
see.
Bench.
Yes, Mr. Bhuya, did you look into it, the report?
Yes, yes. I've gone through it, my lord. There are two writ petitions, my lord. One is for compensation. Now, with regard to that part, compensation part, a person who has alleged to have committed an offense in police custody and he commits suicide. And in that case, my lord, whether he will be taken as a victim Of course, my lord. That is with regard to, my lord, International Committee of Red Cross, my lord, wherein it has been defined in page 8. If your lordship, I have given the guidelines for investigating death in custody, my lord. Page 8, if your lordships come to page 8. Definition branch, my lord.
Page
8, my lord. Definition. Irreversible so and so vital function, including brain activity, that is natural when it is caused solely by disease and or aging process. It is unnatural when it is caused or external, such as intentional injury, homicide, suicide, negligence, or unintentional injury, death by unintentional injury. So now, if your lordship go through the judgment, I have placed on record, my lord, 2017-10 SCC, my lord.
hey, get a yellow at a yellow. The green, yellow at a. Yes, oh, got it.
Yes, 2017-10 SCC 658 judgment, my lord. Paragraph 9, if your lordship come to paragraph 9,
Just one
this
minute.
particular report has been, my lord, relied upon, my lord.
So you are referring to page 8.
Yeah, that is with regard to deaths. What is unnatural deaths? Suicide or negligence or
That
other?
is a irreversible cessation of all vital functions,
Yeah.
including brain activity. That is natural when it is solely caused solely by disease or aging. Unnatural when it is caused, others are external, such as intentional injury, homicidal,
Homicide and
negligence,
suicide.
or unintentional injury, death by accident. Yes.
So here, my lord, I have submitted one judgment also, my lord, will kindly see to it, 2017-10 SCC 658. Here, my lord, this report has been, Honorable Supreme Court has relied on this particular, my lord, report of the Red Cross, and it's been directed that central government should, my lord, circulate it to the state government also. Paragraph 9, my lord. And in this case, my lord, compensation was paid. It was a case of custodial deaths, my lord. Relevant para are, my lord, apart from 9, is 52.
Page?
50, paragraph 52, 53, 54, and 55. my lord.
Then
53, my lord. Fifty-four and 55, my lord.
does it say anything about even a suicidal death?
Yes,
Where?
my lord. Para 9, that is been referred to with regard to this also, my lord. Para 9 said suicidal case, negligence case will also be covered, my lord, referring to these guidelines. And Here was a case with regard to, my lord, unnatural death in prison, my lord. And unnatural death, any case of unnatural death, my lord, custodial death, my lord, that will cover this, my lord.
No, no. Yeah, finally come to paragraph 41.
41. Yes. One, the issue of compensation for unnatural death in custody is no longer integral. One of the earliest cases was granted copy of the petition particular of the so and so. That was not one of the custodial death, but was of a case of illegal detention even after acquittal in full trial. This court held that the petitioner was entitled to compensation for the illegal detention and rejected the stale and sterile objection of the state government that the petitioner may, if so advised, file a suit for recovery damages. This court took the view that the refusal to pass an order of compensation would be doing mere lip service to the fundamental right of liberty of the petitioner under Article 21 of the Constitution of the state government had to grossly violate. This court observed that if civilization not to perish in this country as it perishes in some others, too well known to suffer mention, it is necessary to educate ourselves into accepting that respect for the rights of individual as is true bastion of democracy. A little later, so and so. Well, what is stated in paragraph 9, relying on this, my lord, even a case of suicide while in police custody will cover. And he will be taken as a victim, my lord.
Finally come to page 682.
682.
First one.
Yes. The under trial victim died in judicial under suspicion. The postmortem report indicate cause of death was asphyxia as a result of strangulation and antemortem so and so blood. The Guwahati High Court awarded compensation for unnecessary so and so. Yes, ma'am.
We looked into the judgment because this seems to be similar to the
Yes,
present
my
case.
lord, I have not gone through this judgment, my lord. I will, my lord, if your lordship allows. My lord. Apart from that, my lord, what I am on, that, my lord, this government, Nagaland government have that particular, my lord, victim compensation under Nagaland Victim Compensation Scheme of 2012. In Assam also it is there. I have furnished a copy also, my lord. Assam, it was 2 lakhs, my lord. Subsequently, it was raised to 5 lakhs. But here, Schedule 1, my lord, it's been there, my lord. Loss of life, 2 lakhs compensation, my lord.
This is on 357A.
Yes.
That is different.
My lord, even then, my lord, suppose a victim, my lord, who has been accused has been acquitted, even the victim is entitled to this. So anything with regard to, my lord, here the victim happens to be a person who is alleged to have committed an offense. So he comes within the purview of victim itself, my lord, because he died while in custody.
This is different. It would be one thing one can very well say that you can take this as a measure.
Yes.
As a measure to assume to say what would be the compensation.
Yes.
That's all.
Yeah.
But otherwise, this victim compensation scheme would not apply in the case of an
Person
death
committing
by
suicide. My respectful submission is this, my lord, that if we go by the law that has been interpreted time and again. Now, a person in judicial custody or in police custody, custodial legacy, and a person dies in police custody or otherwise judicial custody, and for that is unnatural death. In that case, he comes within the purview of the definition of victim itself.
No, understood. That is another, you may come under the purview of a definition of victim and he may have died, that they may be entitled to. That is another aspect. I'm
Right.
not on that. But the question is, if a person concerned, isn't it the duty? Because of the officer in
Right.
whose custody he is,
Yes.
even vicarious,
Yes, ma'am. Of course, ma'am.
that as he is in his custody, it is
The
his
person has died.
responsibility,
Yes.
unless it is a natural death.
Unless it is a natural.
Just for example, he had died with old age out there, he died out there
Of
or
a heart
something,
attack, my lord.
or a heart attack or something to
Ah.
that effect.
Absolutely.
But when he has been found to be dying out of the strangulation, which is a suspicious circumstances,
Yes.
and therefore this case of the Guwahati High Court in the case of Bheduki Borguhai
My lord.
may be of relevance.
Yes.
2013.
Yeah.
That would be of relevance, and
I have also, my lord, gone through the in details, my lord, with regard to the inquiry that has been conducted, my lord. Very shockingly, my lord, the persons who were examined in this inquiry, all evasive answers. And my lord will kindly see, when a person dies, all of a sudden, then same has to be registered as a UD case, my lord. So now UD case, what has been the seizure been made? Absolutely nothing in the inquiry report. And apart from that, if you'll just come to the inquiry report itself at page 13, my lord, can we see? Page 13, paragraph, second paragraph, I'm pointing out to this court. This witness, my lord, that he has been examined, my lord. And what he stated, my lord, in paragraph, page 13, paragraph, second paragraph. He stated he even turned back to the PS through his duty period was over. On reaching the PS, the Muslim community was crowded in the PS premises, and after some time, the higher authorities took the data storage of the CCTV footage, and after seeing the CCTV footage who were present, they were relieved and agreed to take back the dead body of late so and so so and so. So now this data footage, my lord, is never been part of this whole inquiry. What is part of the inquiry is some mobile recording, my lord. That is at page 45, no? 45 of this inquiry report. Yes. All answers are evasive, my lord. May I read the question, my lord, page 45 of the inquiry report? Have you taken the whole footage of the CCTV of both 2910, 3011 to 8 investigation being the IO? The CCTV footage of 3011, 2000 only been taken. Then why did the extract only of the CCTV footage of 3010 and not 2910 also? The incident happened only on 3010, 2016. Therefore, the CCTV footage of 2910 was not extracted. From where did you extract the CCTV footage which you have submitted in your final report? Did you take the help of any expert or any other persons to take out the CCTV footage? The CCTV footage which has been submitted by me along with the final report was extracted by recording from a mobile handset belonging to so-and-so community of the deceased while was displayed from the monitor in their presence from the police station and not indirectly from recording set-top box, as there was no expert to extract the footage, which I also took the extract of the CCTV footage from the mobile of the person of so-and-so community. The extract of the CCTV footage was taken in presence of the OC and the so-and-so community based in Kohima. So where is this one? And Other thing, my lord, wherein, my lord, it can be said, my lord, that no witnesses stated, my lord, that how UD case is registered, place of occurrence has to be, what has been found in the place of occurrence, that has to be recorded. There is nothing in the inquiry. At page 14, if your lordship come to second paragraph, he talks about blankets and all such things, but nobody says that on that particular day blankets were there, or this one, or any other materials, my lord. All evasive answers, my lord. Second paragraph, my lord, he cannot remember the height of the ventilator, but the grills of the ventilator were fixed horizontally. He can't remember how many grills were fixed on the ventilator. There was one blanket along with other crutches which he cannot remember.
Who was the person concerned when he was there, this incident happened? Who is that witness?
Yes, my lord. Yes, that is page 26, my lord. UBC Kelangotos Sale.
Incident happened at what time?
Between 8 a.m. to 8:15.
There must be a postmortem report.
Yes, my lord, postmortem report, again, my lord, we kindly see as
No,
per
no,
the
what does it say?
postmortem report, my lord. Page.
Incident happened at?
Page. It has been discussed, my lord. I have not have the postmortem report, but it's been mentioned in page 58. 67, my lord, at the inquiry report.
What does it say?
Yes. External finding, my lord. He was average build within 180 centimeter. That is 5 feet 9 inches. I have done through the postmortem examination of body, rigor mortis, so and so, staining so and so, liver so and so present on the back, which usually occurs.
No, no, I'm saying time of death has been given, no?
Yeah. So for time of date is concerned, my lord, conducted the postmortem. It will be in the postmortem report, my lord, 4 to 6 hours, my lord, at page 68.
No, because here the window would be way less
Yes.
compared to, because it would be the case of these witnesses itself. They
Yeah.
will be saying at what time this must have happened.
Yes.
So they must have, this happened in the bathroom.
Yes.
He couldn't have been there for bathroom for a long time.
Absolutely.
So therefore, there would be a particular timeline when the witnesses have stated that they were
Yes,
in the
between
bathroom.
8 to 8:15, my lord, on that particular day.
8 a.m.
8 p.m., my lord. 8
8
a.m. to
a.m.
8:15.
to 8:15.
8:15 to 8:25, I'm sorry, ma'am. And the time of date, my lord, that's been reflected in the postmortem report, page 68, my lord. Age of the injuries 2 to 3 days from the time of examination. Time since date is 4 to 6 hours. And a person of 5'9" height, my lord, and that particular ventilation is at 6, my lord, foot. One can, well, his legs were touching the this floor, my lord. Now, where is that knot is been found, my lord? That would be very important because a person can die in that manner also. And the material that has been used is stated to be a pillow cover, my lord.
So this seems to be the, what has happened at page 26.
Yes.
Page 26, page sheet, my lord.
Page 26, Mr. Longcheck.
Yes. And
Yes. Page sheet, page 30 is below cover. Or
It's okay.
page sheet.
After this, no, you see, till 8 o'clock, this person comes at 8 o'clock. And after 8 o'clock, when they saw him, he was sitting. So till 8 o'clock, he was there.
Yeah.
Then he stood up and said that. Then he even told him that time is coming, that Saab is coming, so and so. After this, both of them came out of the lockup and they met so and so around 8:15. And they informed him that there is one person lodged in the lockup, and so he called so and so to come and see the accused. However, when they reached the lockup, they called up so and so, there was no. Then how did he go from the lockup to the bathroom?
that CCTV camera is also not there.
Huh?
Footage
Madam?
never been produced.
How did he go from the lockup to the bathroom?
Your Lordship, I come again, Your Lordship.
See, if you see the evidence of this UB Keleng Goto Saleh, which is at page 26,
Yes.
he says that this person, Jalaluddin, was in the lockup
Yes.
till 8 p.m., 8 a.m. Because this person met him at 8 a.m. when he came.
Yes, Your Lordship.
Then how did he go to the bathroom? Is it allowed?
Yes. Your Lordship, if we say this one, on this morning, Your Lordship, he was supposed to have the IO is supposed to have an interrogation with him.
No, very good.
Yes, Your Lord.
I was doing the right thing, but I'm only asking you, how did he go from the lockup to the bathroom? He could go from the lockup to the bathroom only in presence of an officer or some police constable or whoever it is. You don't allow, he must have taken somebody's permission because the bathroom is not inside the lockup.
No, bathroom is inside the lockup, Your
Inside the
Lordship.
lockup.
Bathroom is inside the lockup, Your Lordship. There's a CCTV, Your
It's inside
Lordship.
the lockup.
Inside the.
It's inside the lockup, Your
The
Lordship.
question out here, the CCTV footage for that purpose only. How, when he goes in and when he comes out, why it is not there? Why that original CCTV is been taken away and that recording by a mobile has been shown? I don't understand this.
And he was alive.
He was showing some sign of life, Your Lordship, and therefore he was brought down and they massaged, gave a massage, and since like his condition got worsened, so they took him to the hospital, Your Lordship.
So where is the CCTV footage?
No, that is the problem, Your Lordship. Last time we submitted, Your Lordship, I submitted that CD, Your Lordship. However, Your Lordship says that the inquiry has to go, and you don't find it satisfactory, and therefore, like this inquiry was actually conducted, Your Lordship.
Understood. But where is the CD for the CCTV footage?
Your Lordship, here I just want to make one slight clarification, Your Lordship. Previously, it was taken by my colleague, like who has now expired, and he has not included that in the office record, Your Lordship. But I think there was actually a copy from the magistrate, Your Lordship. So it might be in the record, Your Lordship. Otherwise, I have a copy with me also.
Because if I remember this matter, which I heard it a long time before earlier,
Yes.
there the CCTV footage which I was shown did not show anything, isn't it, Mr. Longchar?
No, no, it was showing, Your Lordship. The only dispute is that the petitioner, I mean, like they were saying that there's some lapses here, like some video clipping has been deleted and all these things. And yes, I admitted that video is not clear, Your Lordship. But it's there. He was like seeing going inside the bathroom, coming out, again going inside. I mean, he was laying over on the bed. Again, he will walk up, sit on the bed, and he was seeing going inside the toilet. So there's a thing. I mean, we can see that one, Your Lordship. And after some time, he was brought outside. We were seeing police rushing inside the toilet also, Your Lordship.
My lord, about the CCTV inquiry report, page 77.
Page?
Page 77, Roman 11. That means they have destroyed it.
Was thought about the status of the CCTV installed in the South Indian for Iman. Stated that the old CCTV which was installed earlier was not working properly, so the whole set was replaced by a new one in 2023. As per the statement of so-and-so, he stated that the old CCTV which was installed earlier was removed, and as per the direction, as 16 inch here, all so-and-so was happened. Now, this incident happened when? In 2016.
2016.
30/10, 2016.
30/12/2016.
13/10.
Installing a new CCTV is fine, but they cannot destroy the evidence about that particular.
And if your lordship come to page 28 of the inquiry report, there has been a person who monitors the CCTV camera. At page 28, my lord, will kindly see the
Page
question.
8.
28, my lord. At what time you find Jalauddin hanging in the toilet? What was the time he was taken to hospital? I found Jalauddin hanging about 8:15 a.m. But cannot remember the time he took him to hospital. Is Jalauddin complain about any pain, so and so, so and so? No. Jalauddin stated that he was fine. Have you been monitoring, watching CCTV footage during duty period? That means it's been working, my lord. The CCTV footage is monitored by the duty officer, and at that point of time, the monitor of CCTV was not working well. So why you have taken up the it's not working? Why you have taken away whole of the CCTV footage, my lord?
My
That
lord.
already I have pointed out.
Your Lordship, the CCTV is already fixed in the lockup, Your Lordship. We have to know that it's already there. It's not that just for this incident it's captured. It's not like that. It's there, except that the CCTV does not monitor the toilet, Your Lordship. So maybe the working system, I mean, Your Lordship, maybe there need to be an upgradation, or maybe that sort of things might have arisen. However, Your Lordship, it is not that only for this incident, it was not working, it was recorded. It's not like that, Your Lordship. It's already there, but the technical lapses may be there, Your Lordship.
Page 13, paragraph 7. After some time, higher authorities took the data storage of the CCTV footage. And after seeing the CCTV footage who were present, they were relieved and agreed to take back the dead body of late so-and-so. Now, where is this CCTV footage? That was never been produced during the inquiry.
So this inquiry report is being submitted without the CCTV footage, no?
Yes, since it was not available at that point when the inquiry was conducted, Your Lordship. It is written, Your Lordship, in the findings. It is written in the findings, Your Lordship, that the CCTV recordings is not available, Your Lordship.
There is a CD here, wait.
The CD will be consisting of post-mortem as well as the footage of the lockup, Your Lordship.
The original postmortem report, the origin case. How did he tie that? Where did he get the cloth?
Your Lordship, as per the record, Your Lordship, as per the affidavit, Your Lordship, of our affidavit, it is a bedsheet torn. A piece of cloth was taken out from the bedsheet, Your Lordship. And when we see the CCTV, Your Lordship, we can see that he was doing something inside the blanket.
So the bedsheet, so there was some bedsheet out there.
Yes, Your Lordship, because what happened is that
Is
it's
that
very
bedsheet?
cold. It's very cold in Kohima, Your Lordship. So, Your Lordship, literally they have to sleep on the floor.
Huh?
So, Your Lordship, October 30, Your Lordship, Kohima becomes very cold, Your Lordship. So, Your Lordship, because of that, the bedding was provided, Your Lordship. If we see the CCTV, Your Lordship, there's something going on inside the blanket. I mean, inside that bedsheet, Your Lordship. He was doing something, but that cannot be actually seen outside. But we can see that movement, Your Lordship, because as per the affidavit, Your Lordship, it is stated like that.
My lord, if I may be allowed to.
Just 1 minute, Mr. Longcha. Let me have a look at this. There's some CD out here. Which one was in the TV? Okay. Was the medical report taken prior to he being brought in? Yes, sir. Before we. That is there, my lord. While taking custody, my lord, before that, he was taken to Naga Hospital Authority for him on 29/10. Does it say anything about injuries? Uh, Swelling at the rate, eyelid and abrasion. Left abrasion. Eyelid, there is some injury and abrasions. And left something. Armpit.
armpit, and once medicine was prescribed, one tablet was prescribed.
Was the doctor who was the doctor examined in the inquiry report?
Yes.
What did he say? He was brought dead?
Yeah. Dr. Rupert Pessier. That is his finding, my
Page
lord.
33. Doctor examination is on page 33. Page 33.
Group 3 page.
Ako ay divorce. Ako ay divorce. So he's, ডাঙৰ কৰি দিবচোন। So, Ms. Devika, tell me why this is, you don't have, it was taken up only by mobile camera? And not the CCTV camera footage is there?
Yes, Your Lordship, as I have stated earlier, this case was taken up by my previous colleague. So affidavit was, everything was written. So meantime, while I was like, when the file was handed over to me, I saw that the clipping was not like the actual, I mean, like, it is not a clear clipping. That's why I asked.
Because
So,
what you see from that, if you see the video,
yes,
in one place he's sleeping out there.
yes,
Then you have a door
yes,
that's an ironclad, which I think is the entry
Entrance.
towards the lockup.
Towards the lockup, yes.
So you don't know from where, you don't have any CCTV towards the, what do you call, the bathroom.
Yeah, it's, I was apprised that like there is no CCTV, I mean, near the toilet, Your Lordship,
Or
except,
no, or towards the door to the bathroom.
yes, I mean, Your
There's
Lordship,
no
as far
CCTV
as like,
showing towards the door to the bathroom.
as far as I saw that clipping, Your Lordship, I see that we can see clearly that the person is going inside the toilet. We can see that, Your Lordship. I don't know whether
Don't
that,
know what has happened in the meantime. I mean, you see, the person who entered
yes, Your Lordship.
at that point of time, if you see the last around 6 minutes, last 6 minutes, you see,
Yes.
it is not so clear as to who entered.
Yes, police personnel, they entered.
Then you see all the police officers bringing him to the bed.
Yes, Your Lord, they're trying to revive it. That's what I'm explaining, Your Lord.
It seems, but you don't see how these people have entered properly.
We can see that they're rushing inside. I can also see that clipping only, like they went inside and they brought him back. That I saw in the clipping that I had in my hand. But even my recording, Your Lordship, I have to see it in this position, Your Lordship. That's why I actually asked the concerned police station to give me the CD which has been recorded in the, I mean, computer only, but they were not able to furnish it to me, citing that it's an old case. Because even this case was handed over to me, I think after 2 years or like that. So by the time I inquired, the recording was not available in the system, Your Lordship. So even I have this recording with me, Your Lordship. That is the only recording I have with me. In the tilted position, I also have to see, Your Lordship. We can see that even the chairman of the Muslim community, he was also examined, Your Lordship. Because firstly, they stated that there's a foul play and therefore they were not willing to take the body. So they were shown the CCTV scenes, Your Lordship. So after getting satisfied, they took the body, Your Lordship. The chairman of the Muslim committee was also examined, Your Lordship.
Name? Islam. Page 59.
Page 59, yes. Clause 3. General Secretary of the NGO called Muslim Welfare Society.
He doesn't know anything. He also says that he also saw this same CD.
Yes, Your Lordship.
He didn't see the original one. Although he was very much there.
Very much, yes, Your Lordship.
So at that point of time, only the CCTV is not there. Yes, Mr. Long. Yes, you want to say something?
Yes, my lord, I'd like to make a fair submission.
Ah.
Fair submission without inclining toward petitioners nor inclining toward the state.
You
This
are
been drawn in inference. I would like
you are
to,
for whom?
I am representing the CPI, respondent number 8 in read petition 241 of 2016.
You are appearing for
CPI,
CCI.
CPI.
Oh, CPI.
Yeah, the CPI has been implemented as a respondent number 8 in the read petition 241 of 2016. So I would like to rely on the record. Just rely on the record. If your lordship, you kindly refer to this read petition, page 12. Page 12. This is my fair submission relying on the records. Page 12, annexure 4 is the handing over and taking over of the dead body.
Just 1 minute. Yes.
So then the next annexure 5 for requisition for postmortem. Requisition for postmortem was done on at 1:20 p.m. Then postmortem is likely to have been conducted and embalming was done at 2:20. That is annexure 6, my lord. Annexure 6. Embalming was done at 2:20 p.m. on 30/10/2016. Now, if we come to this annexure 4, annexure 4, it is very clear the handing over and taking over of the dead body was completed on 5:19 p.m. on 30/10/2016. These are records which have been revealed and which is a bit by and parcel of the read petition. And, my lord, if we look into the reply given by the state respondent.
Huh?
Reply of the state respondent. Yes. I'd like to make a reference to the page number is not very much visible in my documents, but exhibit 3, it is a confidential documents. Page, it's likely to be page no.
Page 1.
Annexure 3. Annexure 3, page 18. So all these are the records. Now, if we go to the reports of the doctor concerned, it reports that the postmortem was conducted on 2nd November. Annexure, here it's exhibit, written as exhibit 3. In the page number is not very much visible in my petition, but it's exhibit 3, confidential. Postmortem report. Postmortem done on 2/11/2016. Yes. So certain inference can be drawn. And why I have taken by taking a permission, I'm giving a submission before the honorable court is that something has gone wrong somewhere. And now the petitioner is also seeking a CPI inquiry in this case. But when the entire evidence is now been destroyed, how the CBI can also conduct an inquiry without any proper evidence? There is no CCTV footage. Postmortem report says that it is on 2/11/2016, but the dead body was already handed over on 30th October at 5:19 p.m. So where was how the postmortem was conducted also?
Now, if you come to page 1920, which is the postmortem report itself,
Yes, my lord.
and kindly come to the date on the page 20, the second page. Down below, it is said at 2/11/2016.
Yes.
Yes.
These
Now,
are
prior to that, however, if you see the observations, age of the injury 2 to 3 days from the time of examination, time of death 4 to 6 hours.
my lord.
Death was due to so and so. So this is what is being given.
Yes.
Now, the requisition, this person concerned in his inquiry report at page, where is the doctor's here?
Read petition page 30.
Kindly come to page, no. Kindly, if you see the inquiry report, page 33. The dead body of there was handed over. Now he said, this person of the person who conducted, he stated that he did the postmortem examination of so-and-so on 30/10/2016 at 1:20 p.m. at the autopsy room, which was under the chief ear. The death of ear was handed over to him after finishing all formalities, dead body and so. The wearing apparels was, he was wearing a blue colored shirt, so and so. Now, see the investigating officer's report at page 36 in between. Jalaluddin also admitted before him that he was beaten up by the public, but no external injury was seen except an old bruise mark was seen on the face. Isn't it?
Yes, my lord.
Okay. Now, if you come to the postmortem report, more particularly, let us again come back here. If this is the investigating officer's report, then if you see at page 34, it says black eye on the right side, bluish black in color, which was due to an blunt attempt on the head or directly to the eye. Abrasion below the chin and neck area 8 into 2 centimeters with scape formation, reddish brown in color. Abrasion with scrap formation on the right posterior part of the index finger. Abrasion with scrap formation on the left dorsal part of the hand. Bruise, so and so on the lower limbs and man. Gums bluish in color, bluish becomes blue in color in around the ear due to oxygen depletion in the settled blood. Because he was held on 28/10,
Yes,
isn't it?
as per the fact.
He was brought within the, he was arrested on 28/10.
No.
20.
It was around 0 hour, 29
29 0 morning. Early.
morning.
But so CBI says that the question of giving it investigation for the CBI does not arise.
Yes,
Means
that is a point of view, my lord.
evidence is not there for
Mm.
going for doing it after such a long time. It is
Yes.
around 9 years which have gone by. So that it would make no sense.
Yes, and relying on the documents filed before the Honorable Court with the writ petition as well as with the reply given by the state respondent, there are anomalies in the documents. how a dead body can be taken into postmortem after the dead body was taken away by the relative. It was already handed over as per the records. Record speaks that on 30/10/2016 at 5:19 p.m. the dead body was handed over as per the records. Then how comes the postmortem was conducted on 2nd November 2016?
No, postmortem must have been conducted at 1:20 p.m. only. But the signature was put on 2/11. The report was signed on 2/11.
That may be there, but I'm relying on the records, my lord. I'm relying because it indicates that conducted on two. Then embalmment was done at 2:20 on 30. Embalmment was done also. All right. So I'm just trying to make a sense on behalf of the CPI that when there is no evidence, even the slightest evidence available before the court nor before any other lower courts or any other authority, like CCTV footages or this and that, it is very difficult for the CPI even to go to the for investigation and relying on this document. I'm just making an inference in my humble submission before the.
Bhuya, you have a look at that video, which I saw it.
My lord, I don't have an opportunity even to go through
No, don't worry. I am not going to give for CBI. I
Yes.
told Mr. Longcha long time back, isn't it, Mr. Longcha?
Yes.
I told you, we are only concerned with the compensation. Whether we are to find that there is some negligence or not. If there is a negligence, it's only a question of compensation. But otherwise also, being a victim also, it's anything happens out there, then also 357A, that is there if anything happens. But I'm not on that. The only question before this court is as to whether there was a constitutional tort. If there is the question of compensation will arise. And have a look at the judgment, because the person died. Because there was no, have a look, because this is a video by which it was taken by mobile on the CCTV camera. Yeah. But it's very strange why they could not have the CCTV footage with them.
They've destroyed it as per the finding.
Your Lordship, it is in the system. Maybe, Your Lordship, we need to make inquiry in this, Your Lordship. But as far the inquiry report is concerned, it is not there. However, Your Lordship, as all of us, we are on a common pool, like to bring the right judicious conclusion on this case, Your Lordship. I can also make one endeavor, like whether that CCTV, like, any, because if it's not gone into scrap, maybe,
It couldn't have been. I don't understand why everybody has taken the mobile thing.
maybe, Your Lordship, but that is a thing. So, I mean, like it has
Why
to be
nobody
through
looked
pen
into
drive
this?
or at that point of time, computer, Your Lordship. Everything.
No, understood. They could have this CCTV in 2016 that could have been looked into. They could have kept it out there in the CCTV. They downloaded from there.
It has
So at
to
that
be
point
like-
of time, it becomes
it has-
it can be an evidence under 65B. But the question is, you have put it recorded by way of a mobile. And there is no certificate also to that effect. Who has made this mobile area? Nobody knows what has happened. Now, if there is some doctoring in that, while making the recording, you never know.
Yes, Your Lordship, that for this reason also, Your Lordship, I have also inquired, Your Lordship, because there should be, the recording should be in the system and we need to know that system only. So, Your Lordship, if it has not gone into scrap, maybe if that thing, all thing is still pending, I mean, like, maybe we can make an endeavor, Your Lordship, so that,
Now, we'll do one thing. We'll keep it on again on 10th of June. In the meantime, whatever you can find in the meantime.
if this honorable deems it proper that should be retrieved, then.
You can find out the original CCTV, it's well and good.
Mhm.
Then it's something is there. But this is very difficult to say, because one thing, you see, that portion of the CCTV is not so clear. Only portion which is clear is the resuscitating that the person. The person who enters, that portion is not so clear how they enter immediately. if you see the CCTV properly, that is
Yeah.
what I was looking into it.
Mm.
You have a look at it.
My lord.
Give me my area. Look, মই আছে না আমার। এইটো এটা কপি এটা বনাব পাৰিবনে? হে? এইটো পাৰি? তেওঁক দি দিবচোন। এবাৰ চাই লব।
Definitely.
The matter having been heard, it would be this court during the course of the hearing. Also peruse the, you got the postmortem
Yes,
report is there.
Yes, yes. In the, on the,
It's
in the
already
records,
there.
it is there.
Yes, this court have duly perused the, have also have looked into the DVD which is enclosed to the records. Pusto. Taking into account that said the contents of the DVD would have a vital, would be of vital importance for the purpose of the deciding the instant case. A copy of the said DVD be made so that the same can be furnished to Mr. A.K. Bhuya, the learned amicus curiae, so that he can address this court on that issue. And look into that judgment.
Yes, I
Papa,
will. I will.
List this matter again on 10th of June for further hearing at 2 p.m.
At 2.
Mr. Longchair,
My lord.
10th June, Your Lordship.
10th of June.
10th of June, okay.
Much request.
Yes.
Well,
So finish, dismiss.
well, the exhibit 2, the contents of the exhibit 2, it reflects well the regarding payment of money, etc., everything. And why it was not registered manager?
Huh?
Why sale deed could not be registered, this was also mentioned in the exhibit 2. And regarding possession given to the Bhuvan Mohan, that is also expressed in the content of the document.
What is this document, Exhibit 2?
Exhibit 2, my lord, as per the instruction of your father, Sinmoy Banerjee, my lord, the defendant number 1 executed the document, my lord. Since he was bedridden condition and he was not in a position to execute the document. So agreement to sale was reduced into writing as a fair amount was paid to him, Sinmoy Banerjee. And here it is mentioned also, my lord, it is possession.
Let us read Exhibit 2.
Yes. My lord, the relevant portion, my lord.
Now read the entire one.
Borduar Mouzar. The relevant portion I have got related. Borduar Mouzar, Hatpur Gaon, FA position Teras Medi Patar, Ekpisnum Tagay, Sari Biga Ekota, Garlesa Zomi Moor Pita, Sri Sinmoy Krishna Banerjee, Bina Krishna Banerjee, Nam Nozor Namor Zomi Hoy. পুৰণি ধাৰ পৰিশোধ কৰিবৰ কাৰণে টকাৰ আৱশ্যক হোৱাত পিতা পুত্ৰ ও ঘৰৰ আলোচনা ক্ৰমে উক্ত জমি হতপুৰ গাঁও নিবাসী শ্ৰী ভুৱন মোহন দাসৰ লগত চাপ বিক্ৰীৰ বন্দোবস্ত কৰি তেখেতৰ পৰা টকা পোৱা হয়। অসুবিধাৰ কাৰণে বৰ্তমানলৈ জমি ৰেজিষ্টাৰ কৰি দিয়া নাই। ৰেজিষ্টাৰ কৰি দিয়াত আমাৰ কোনো আপত্তি নাই, কিন্তু জমিৰ সম্পূৰ্ণ দখল স্বত্ব দিয়া হয়। শ্ৰী ভুৱন মোহন দাসৰ জমি বিক্ৰী কৰাটো সঁচা হয়। গতিকে উক্ত জমিৰ ওপৰত ৰাইজে হতপুৰ আঞ্চলিক ছোৱালী হাইস্কুলৰ খুঁটা পুতা বা ঘৰ বন্ধাত আমাৰ কোনো ওজৰ আপত্তি নাৰাখি উত্তৰাধিকাৰ সূত্ৰে মই তেখেতৰ সম্পূৰ্ণ চৰ্ত বাহাল ৰাখিবলৈ লিখি দি নিজৰ নাম সহি কৰি দিলো। This land was given for a high school also then, and it has been written here and he has no objection. And this was the conduct of the person. The PW1 also in his evidence stated that since he is a closed door neighbor, so notice was not sent for registration of the sale deed. With long persuasion all the time.
How the document at all was taken?
My lord,
you mean to say this to be an agreement for sale?
yes, my lord, the evidence is clear, my lord. Since his father was bedridden and as per instruction of his father, he reduced into writing this document, my lord, on his father's behalf. And it is clear, my lord, that is why the
Now, where is the statement that he is going to sell it?
my lord,
Where is his statement that he is going to sell it?
গতিকে উক্ত জমিৰ ওপৰত here itself it has been said. লগত চাপ বিক্ৰী বন্দোবস্ত কৰি তেখেতৰ পৰা টকা লোৱা হয়। অসুবিধাৰ কাৰণে বৰ্তমানলৈ জমি ৰেজিষ্টাৰ কৰি দিয়া হোৱা নাই। That impliedly, my lord, the meaning is implicit, my lord, in the document itself, my lord.
Then where did he say that he is going to register it?
No, nothing, my lord.
Then where is the agreement?
No time has been.
There was an agreement. He said there was an agreement, but due to some difficulty, there was no the sale deed could not be executed. That's all.
But
it's not an agreement for sale.
ওজৰ আপত্তি নাৰাখি উত্তৰাধিকাৰী সূত্ৰে মই তেখেতৰ সম্পূৰ্ণ চৰ্ত বিলাক বাহাল ৰাখিবলৈ ৰাখি এই লিখি দি নিজৰ নাম চহী কৰিলো। That means the contract earlier was there, matlab only one judgment maybe Paris matlab in conduct of the party matlab the Supreme Court judgment.
Conduct, if you will go, you are in more bad position.
Paragraph 16 matlab. Before we advert to the said question, we may consider the effect of refusal on the part of the second defendant to execute the deed of sale within 20 days from the date of entering into the said agreement for sale. We have noticed here before that father-in-law of the respondent number one category stated that he at all material times was ready, that the second defendant was refusing to execute the agreement for sale, agreement of sale. They had therefore the notice that the defendant number one had refused to perform his part of contract. The suit should have, in the aforementioned situation, been filed within 3 years from the said date. We are not oblivious of the fact that performance of a contract may be dependent upon several.
So this goes against you.
Matlab the conduct of the parties, matlab the
Heard Mr. D. Chaudhary, the learned counsel appearing on behalf of the appellant, and Ms. S. Chakravarti appearing on behalf of the respondent.
Number 1.1, 1.2, 1.3.
1.1, 1.2. An appeal filed under section 100 of the Code of Civil Procedure challenging the judgment and decree dated 29/3/2008, passed by the learned civil judge, senior division number 1, Kamrup at Guwahati. For short, the learned first appellate court, entitled appeal number 76/2001, whereby the judgment and decree dated 21/7/2001, passed by the learned civil judge, junior division number 1, Guwahati, entitled suit number 402/1994. Junior division number 1, learned trial court, Guwahati, was set aside and quashed. It is seen from the records that the coordinate bench of this court, by an order dated 3/12/2008, formulated two substantial questions of law. Subsequently, this court, by an order dated 9/5/2024, also formulated another substantial question of law. The three substantial questions of law therefore formulated are reproduced hereunder. Etu page 3 teta ase, mane order sheet 312 aru 95 jonkita substance. For the purpose of ascertaining as to whether the said substantial questions of law are duly involved in the instant appeal, this court finds it relevant to take note of the facts which led to the filing of the instant suit, instant appeal. The materials on record show that for the sake of convenience, the parties herein are referred to in the same status as they stood before the learned trial court. One Bhuban Mohan Das, as plaintiff, had instituted the suit being titled suit number 402/1994 against the defendants who were the legal representatives of late Binoy Krishna Banerjee. Who's- The case of the plaintiffs herein was that that Binoy Kumar Banerjee, who was the owner and in exclusive possession of a plot of land measuring 4 bigha 1 katha 11 lechas, covered by dag number 31 of KP Pata number 125 of village Sudpur, Moza Bordoar, the land more specifically described in Schedule A to the plain, on account of urgent need of money, had contracted a loan of rupees 1,500 from the performer defendant number 4, and in that regard had executed a registered deed of mortgage bearing deed number 1972 dated 4 to 1969. It was for the further case of the plaintiff that at the time of execution of the said registered deed of mortgage, the possession of the land described in Schedule A to the plaintiff was handed over to the performer defendant number 4. Full stop. It was a further case of the plaintiff that in terms with the mortgage deed entered into, the said Binoy Krishna Banerjee was to repay the amount of loan within 3 years from the date of execution of the mortgage deed at the rate of with interest interest at the rate of 12% per annum to the performer defendant. And if if the said Binoy Krishna failed to repay the said amount within the stipulated time, it will remain the mortgaged with the performer defendant number 4. It was also a stipulation that the performer defendant number 4 would deduct ₹6 from the amount loan from the income of the mortgage property every year. It was the further case of the plaintiff that the said Binoy Krishna failed to repay the amount up to 12 years since the date of execution of the mortgage deed. And as such, he entered into an oral agreement with the plaintiff to sell the land described in Schedule B, which is a part of the Schedule A land, for a consideration of ₹5,000. In terms of the oral agreement, as stated by the plaintiff, the plaintiff was required to pay ₹5,000 as the price for the Schedule B land before execution of the sale deed. and the plaintiff was to pay the loan amount with interest due to the performer defendant number 4 on behalf of the said of late Binoy Krishna, and get the mortgage release from the performer defendant number 4 and receive the delivery of possession of the land from him by paying rupees 2178, which would be the total consideration. It is the further case of the plaintiffs that on 24/1/1981, the said amount was paid by the plaintiff. The amount of rupees 2178 was paid by the plaintiff to the performer defendant number 4. And the performer defendant number 4 had delivered the possession to the plaintiff of the Schedule B land by putting an endorsement on the body of the registered deed on 24/1/1981. It was the further case of the plaintiff that the plaintiff had paid rupees 2822 to late Binoy Krishna Banerjee during his lifetime, sometime in the year 1981. And thereupon requested late Binoy Krishna Banerjee to execute the deed of sale. It is the further case of the plaintiff that the plaintiff on various occasions requested late Binoy Krishna Banerjee to execute the deed of sale. But he did not execute the deed of sale, and instead, in the year 1989, he expired. Be that as it may, it is the further case of the plaintiff that after making of the payment, that the defendant number 1, who is the son of late Binoy Krishna Banerjee, had executed a document on 11/12/1981, admitting, acknowledging the receipt of the consideration amount and admitting the delivery of possession of the land to the plaintiff, with a promise to execute the sale deed. First, even after the death of late Binoy Krishna Banerjee, as the defendant number 1 did not execute the sale deed, the plaintiff filed a suit seeking declaration or seeking a decree directing the defendant numbers 1, 2, and 3 to execute the registered deed of sale in respect to the Schedule B land in favor of the plaintiff by accepting the price of the stamp with the specified time. And if the defendant number 1, 2, and 3 fail to execute the deed of sale after the passing of the decree, the court should execute the decree in terms with the provisions of Order 21, Rule 34 of the Code. In a said suit, the defendant number 1 filed his written statement, wherein various pleas were taken as regards the non-maintainability of the suit. First, it was a specific case of the defendant that the father of the defendant number 1 took a loan of rupees 1,500 and mortgaged 4 bighas of land to the performer defendant number 4 by a registered mortgage deed. And in the said mortgage deed, the conditions were duly described. It was further mentioned that as per the mortgage deed, it was agreed that in return of the interest of rupees 1250 per annum of the total 1500, the subject matter of the case, a plot of land at measuring 4 bigha would be possessed and cultivated by the performer defendant number 4. Pustu. It was further mentioned that for that the possession was mortgaged by deducting rupees
Page 42. Paragraph 3.
12.50. It is not 1250. Return of interest of rupees 12.50 per annum of the total 1500. And for that, the possession is mortgaged by deducting rupees 6 per annum from the principal of rupees 1500. It was further mentioned that apart from the deduction on payment of the rest amount of the rupees, the executed would be able to get back the possession. It was also mentioned that on expiry of the term, if the land is not released, the possession will be continued as per the mortgage deed. The defendant number 1 denied any oral agreement entered into by and between the plaintiff and late Binoy Krishna Banerjee. And further stated that in reality, without the expiry of the limit of mortgage deed, the fact of executing such agreement was baseless. It was further stated that a registered deed cannot be finished. It was further stated it was denied that a plaintiff had given rupees 2174 to the defendant number 4 and further asserted that the plaintiff had no authority to give money to the performer defendant number 4. And similarly, the performer defendant number 4 had also no right to give the possession back to the plaintiff. And if such possession was handed over, it was contrary to law. It was also mentioned that when the mortgage was created by way of a registered document, the redemption to the said mortgage has to be done by executing another registered document on full payment of the money by the person concerned. On the aspect pertaining to the document dated 11/12/1981, it was categorically stated that the plaintiff had made that document a false document only with had made the false document It was further stated that the question of, as there was no oral agreement entered into, or any agreement which was entered into by and between the plaintiff and the defendant, or his predecessor in interest, the question of the plaintiff asking the defendant to execute the deed of sale did not arise. Full stop. It is very pertinent herein to mention that amongst the various pleas which were taken, that the suit was also barred by limitation. From the record, it reveals that the learned trial court framed as many as 4 issues. Page 29, which have been produced herein under. First, on behalf of the plaintiff, 2 witnesses were examined and certain documents were exhibited. On behalf of the defendant, the witnesses were cross-examined, plaintiff's witnesses were cross-examined, but there was no evidence adduced. The learned trial court, by the judgment and decree dated 21st of July 2001, decreed the suit in favor of the plaintiff. It is very relevant to take note of that while deciding the issue number 1, which pertained to as to whether the suit was barred by limitation, the learned trial court observed that though the defendant had averred in the written statement that the suit is barred by limitation, but the burden lies on the defendant to substantiate this averment. But there was nothing on record. The learned trial court further observed that the plaintiff, having requested the defendant repeatedly to execute the sale deed, But the defendant number one, instead of executing the sale deed, mutated his name in the chitta, which was subsequently cancelled by the circle officer Polasbury by an order dated 24/1/1994. The learned trial court therefore opined that the conduct of the defendant number one therefore appeared to be refusal of the performance of the contract, and in terms with the second part of Article 54 of the schedule to the Limitation Act 1963, the suit was instituted within the period of limitation. In respect to the issue pertaining to as to whether there was a contract between the plaintiff and the father of the defendant numbers 1, 2, and 3, which was issue number 2, the learned trial court observed that from the evidence on record, as well as the oral evidence, it was crystal clear that there was a contract between the father of the defendant number 1, 2, and 3 and the defendant number 1 and the defendant number 1 and the plaintiff for execution of the sale deed in respect to the suit land. On the issue pertaining to as to whether the plaintiff was ready to execute his part and the defendant number 1, 2, and 3 were neglecting for executing the deed in favor of the plaintiff, which was issue number 3, the learned court observed in the affirmative in favor of the plaintiff. And accordingly, the issue number 4 was decided in favor of the plaintiff. Being agreed that defendant number 1 preferred an appeal before the court of the civil judge, senior division, number 1 Kamrup at Guwahati, which was registered as title appeal number 76/2001. The learned first appellate court reversed the findings of the learned trial court and came to an opinion that redemption of the mortgage could not have been, was not permissible at the instance of the plaintiff. The first appellate court opined former defendant number 4, after getting the loan amount, relinquished his claim over the mortgage property and delivered the possession in favor of the plaintiff without the consent of the mortgagor. And even if his right of redemption have been subsisting, it has not been effectively extinguished either by the mortgagor or by a proper decree of the competent court. The learned appellate court first appellate court further observed that in terms with Section 6A of the Transfer of Property Act 1882, the chance of a heir apparent succeeding to an estate cannot be transferred. And as such held that Exhibit 2 was not enforceable in law, inasmuch as the defendant number 1 did not have right over the said suit property as on that date. On the question of limitation, the learned first appellate court observed that as the suit land was still under mortgage and the right to redeem is subsisting, and there was no agreement for sale of the suit land between the plaintiff and the appellant and the defendant, the question of limitation and part performance of the contract by the appellant, by the defendant, did not arise. Being aggrieved, the present appeal has been filed. In the backdrop of the above, this court duly heard the learned counsel appearing on behalf of the parties and have also perused the materials on record. First, in the back, and first, now let this court take into account as to whether the substantial questions of law so formulated are involved in the instant appeal. The first substantial question of law so formulated is as to whether the judgment and decree passed by the learned first appellate court is illegal for not considering the provision of Section 20 of the Specific Relief Act 1963. How is this involved, Mr. Chaudhary? Not involved. It is relevant to take note of that from the facts so narrated herein above, the pleadings of the parties, the issues so framed, and the findings so arrived at by the courts below, there is no foundational facts on the basis of which this substantial question of law arises at all. Accordingly, the said substantial question of law so formulated is not involved in the instant appeal. Next, the second substantial question of law pertains to as to whether the learned first appellate court committed illegality in misconstruing the provisions of Section 60 of the Transfer Property Act regarding the mortgage of the immovable property. First, this court had duly taken note of the judgment of the learned first appellate court. From the materials on record, it is seen that though there was a registered agreement of mortgage by and between late Binoy Krishna Banerjee and the defendant performer, defendant number 4, but the mortgage was sought to be redeemed by the plaintiff. Without there being any registered instrument or without any registered instrument wherein the mortgagor is a party or by a decree of a court. Registered instrument without any registered. Therefore, the right to redemption, which was there of late Binoy Krishna Banerjee, continued with that of the defendant. The learned first appellate court have, in the opinion of this court, therefore correctly interpreted, they correctly dealt with Section 60 of the Transfer of Property Act 1882. And in coming to the finding that there was no redemption of the mortgage by the plaintiff, by the plaintiff, on the basis of the performer defendant number 4 handing over the possession and accepting the amount, as there was no consent of the mortgagor. Further to that, that being a finding of fact, this court cannot interfere. Consequently, the second substantial question of law does not arise. So formulated is not involved in the instant appeal value. The third substantial question of law pertains to as to whether Section 13 of the Specific Relief Act 1963 ought to have been taken into consideration by the learned First Appellate Court. As Exhibit 2 was duly proved. This court have duly taken note of the contents of Exhibit 2. From the very contents of the said exhibit, it is not stipulated that the defendant number 1 would execute the deed of sale. What has been stated therein, that he, the defendant number 1, on behalf of his father, duly acknowledges that his father entered into an agreement to sell the land and but for reasons could not register the sale deed. Full stop. It is also very apposite herein to take note of that Exhibit 2 is dated 11/12/1981. Full stop. This was executed during the time when the father of the plaintiff, of the defendant number 1, was alive. Full stop. It is also an admitted case that the father of the defendant number 1 had the right over the suit land, Schedule B land, till he expired in the year 1989. This court now finds it relevant to take note of. No. At this stage, this court finds it very pertinent, very relevant to take note of section 13. Which stipulates that when a person contracts to sell or let certain immovable property having no title or only an imperfect title, the purchaser or the lessee, subject to other provisions of Chapter 2 of the Specific Relief Act 1963, has a right to compel the vendor, after he acquires an interest in the property, to make good the contract out of such interest. First, taking into account that the plaintiff, that the defendant number one did not enter into any agreement for sale, that he would execute a sale deed on his behalf in respect to the suit land. The question of the question of application of section 13 of the Specific Relief Act 1963 does not arise. First, next, this court, apart from the above, finds it very pertinent to take note of that it is the very case of the plaintiff that in the year 1981, there was an oral agreement for execution of the sale deed in respect to the Schedule B land. And it is also the case of the plaintiff that in the year 1981 itself, the plaintiff had paid the remaining amount to the defendant, to the father of the defendant, number one, defendants. First, Article 54 stipulates the period of limitation for a suit for specific performance to be a limitation. Where the trial court judgment?
Page 24.
To be 3 years in respect of, to be 3 years. Right, limitation act. Has anybody a limitation act? Okay. To be 3 years. From the date fixed for performance. And if no such date is fixed, when the plaintiff has noticed that the performance is refused. The defendant have denied that there was any oral agreement or even the document being Exhibit 2. First, a perusal of the claim do not disclose as to when the execution as to whether there was any time fixed for execution of the deed of sale. First, be it as it may, it is seen from the perusal of the very plaint that the agreement was entered into in the year 1981. There was an oral agreement in the year 1981 as per the plaintiff, which was subsequently endorsed by Exhibit 2 on 11/12/1981. First, the plaintiff himself states in his plaint that on various occasions he have approached late Binoy Krishna Banerjee for execution of the sale deed, but that same was not done. First, after the oral agreement in the year 1981, late Binoy Krishna Banerjee expired in the year 1989. And thereupon, even after the defendant number 1, who became one of the co-sharers in respect to the scheduled land, in respect to the suit land, the suit was filed in the year 1994. First, there is not a single mention as to when there was a refusal. First, it is very relevant at this stage to take note of the provision of Order 7, Rule 6, which mandates that there is a requirement to state in the plaint as to how the suit is within the period of limitation. There is no mention to that effect. And merely, and the plaintiff have waited for a period of 13 years, more than 13 years, for institution of the suit. In the opinion of this court, the suit was also barred by limitation, which the courts did not take into consideration. Accordingly, this court does not find any merit in the instant appeal, for which the merit appeal stands dismissed with cost quantified at rupees 11,000. In addition to that, the defendants shall be entitled to cost throughout the proceedings. LCR be returned. are the matters I fixed step 2? Whose matter?
Then 7.
Yes, who wants to go where?
Lordship, this transfer decision is filed by the husband.
Why?
Here the respondent, they have filed a petition before the learned family court seeking divorce.
Ah.
Your Honor, the petitioner and the respondent, they have solemnized their marriage on 2/3/2015, according to the Hindu customary law in Nagaon jurisdiction, Lordship. Lordship, but they have filed their petition here in Kamrup Metro, Lordship. So the original jurisdiction would be Nagaon. Lordship, the address the respondent has suppressed material facts are the material facts are wrong, Lordship. They have wrongly put the address, which is village 2, Ubam Khetri district, Kamrup Metro. But in the petition which they have filed before the learned family court, they have clearly mentioned in the point number 7, Lordship, that the petitioner is legally married wife of the respondent. The respondent here is the husband. The petition they have filed before the learned family court between the petitioner and the respondent is arranged marriage, and the marriage has been solemnized in 2/3/2015 at the parental home of the petitioner, situated at village Sakoregaon of Nagaon district, Lordship, and under the jurisdiction of this honorable court as per religion, rights, and social custom. If the jurisdiction here is Nagaon district, then how can they file a petition before the Kamrup Metro, Lordship? They filed this petition before the Kamrup Metro, Lordship.
So,
Lordship,
withdraw or dismiss?
Lordship, the case may be transferred to the original jurisdiction, Lordship.
Why?
Nagaon, Lordship.
Why? Have you seen section 9? Have you seen section 9 or not? Section 9? This Family Court Act. Family Court Act is what? Section 9 or 22? No, Family Court Act or Hindu. The jurisdiction shall lie in 3 places. First, where the marriage took place.
Yes, the marriage took place.
Second, if the marriage had taken where both of them last resided together. And third, if it is the case of the wife, where the wife resides.
Yes.
So,
Lordship,
wife resides.
Lordship, the annexation number 5, Lordship, it clearly states that from the residence and from the work of place she is residing now is 7.5 kilometers. So, Your Honor, it is purely.
Annexation number?
Annexation number 5, Lordship.
Ah.
It is clear, Lordship, that here it's written the distance
Present
between the.
school of Queen Das is so and so. Queen Das is mutually transferred with Deepika. The distance between so and so. How is it relevant? Where she goes is how is it relevant?
Lordship, Lordship, the respondent has already filed a petition before the learned additional district and session judge at Nagaon, Lordship, which they have withdrawn. And again, they have filed this petition before the learned family court at Kamrup Metro, Lordship. The annexure is at page number 24, Lordship, annexure 4, Lordship.
So,
Lordship, it may be transferred to the original jurisdiction.
Hey, condition. Hindu have, yeah, family, Hindu marriage act.
Hindu law. Lordship, in section 19 of Hindu Law Acts,
What is it?
it says that court to which petition shall be presented.
Hmm.
Every petition under this act shall be presented to the district court within the local limits of whose original civil jurisdiction. The marriage has been solemnized in Nagaon.
Oh, further.
The point number one, the marriage was solemnized or the respondent at the time of the presentation of the petition resides, the parties of the marriage last resided together. In case of wife, is the petitioner where she is residing on the date of presentation of the petition.
Are these not all?
Yes, Lordship, but there is no evident proof that
Uh-huh.
she is residing there, Lordship. There is no proof of residing there. The address she has provided us, there is no proof, Lordship. If they have given us an affidavit also in reply, we would have given a reply, Lordship. But there is no proof that the address is residing in. It's
Oh. You have a copy of the petition?
No, Your Worship, we have filed this present transfer case, but we have entered our appearance on our own. We came to know about the present case only when in family court they take for stay of that case, and family court accordingly stayed the divorce matter, and only then we came to know about the matter. And Lordship, till now, till date, they did not furnished us with copies.
Huh?
They have not furnished the respondent with copies of the case. We don't have any copy, Lordship. And the petitioner resides within the jurisdiction of Kamrun Metro District, Your Lordship. But her workplace is at Nagaon. Her workplace is at Nagaon, but she resides here in Sonapur with her aunt, paternal aunt.
They
along
go
with
to
her
Nagaon.
so if
But
Lord,
her workplace is at Nagaon, but she resides within the jurisdiction of Kamrun Metro. She resides.
So
at
you will
Sonapur.
go every day to Nagaon?
Yes, Your Lordship.
Then what is there? Go there.
No, Your
Lordship,
Lordship.
they have just now they have accepted the fact that the respondent is from Sunapur, but here it's Ulubari. Ulubam, sorry, Ulubam Khetri.
So why do you have to
Ulubam
come to
Khetri.
Guwahati?
Yes, Sonapur Khetri, it's never place. No, Your Lordship, in that place in Nagaon, earlier the respondent filed a divorce petition in Nagaon, but the petitioner husband caused much trouble. He threatens us, and there are many matters which we can furnish while submitting our rejoinder. Affidavit in opposition.
Counsel appearing on behalf of the respondent submits that she has not received a copy of the petitions. The counsel appearing on behalf of the petitioner submits that he would furnish a copy during the course of the day. List the matter. How much time you want to file an affidavit?
1 week.
Okay, then counsel submits, for the respondent submits that she may be given a week's time for filing the reply. Accordingly list this matter again on 16th of June 2025 in time order passed earlier.
Production list item 1.
This unlisted booking.
Very pleasure, Lord. My Lord, I am the applicant of the FAO number 87 of 24. Here I have submitted an interim prayer pending the disposal of the appeal. When I paid for a direction from this honorable court for a direction to the respondent number 4 and 5 to pay the fixed amount as stipulated in the award of contract, which has been entered between me and 4 and 5. As per the contract, I am entitled to get rupees 82,000 per bus per month from 9/9/2024, 23. The your lordship may take up the IA number 4048, wherein
Who had filed the appeal?
I have filed
Against what order?
against the injunction order passed passed by the civil judge, senior division.
Ah.
uh,
And the order says that you are to be kept for 1 month. Means for 7 buses until 10/1/2025 and the 8 bus till 14/5/2025.
That is another contract, prior contract, which was made between the respondent number 4 and 5 with 1, 2, and 3. My contract was subsequently entered on 10/5/2023. I have, this is an independent contract with the respondent number 4 and 5. Your lordship may kindly peruse.
Now, what are you challenging? I don't understand.
Yes. I am challenging and along with the interim pair.
Now, what is the order you are challenging?
I am challenging the order dated
Yes, Mr. Koilta, what is this?
Because we are both are defendants. What happened in this case?
You are?
Both are defendants in the suit.
Ah.
Lordship, what happened in this case, Lordship, the Delhi Public Schools has issued an NIT Lordship, wherein the third party, Lordship, where Lanet Senior Council, Ian Sahwala appearing, Lordship, in this case, they obtained the award, Lordship, for running eight number of buses, Lordship. That period is when completing, Lordship, we have issued the fresh NIT, Lordship, wherein the LOI was issued in favor of the present appellant, Lordship. And in that period, Lordship, the Borua Industries, which is arrayed as a respondent, Lordship, they have filed a suit before the lower court, Lordship, wherein the injunction was not granted, and that's why they have filed an appeal, Lordship. In this case, Lordship, if Lordship peruse our objection to the IA, this honorable court has passed interim order to the extent of maintain status quo. Lordship, wherein the Delhi Public School has filed an IA, Lordship may peruse the case 100.
What status quo? How they can be a status quo?
Because the injunction was not provided, not granted by the lower court. That's why the that Borua Industries has filed an appeal, Lordship, in this honorable court, and this honorable court has passed an interim order.
Where?
And interim order was passed.
Well, I was saying, huh?
In IA, Lordship, that case was already disposed of. Lordship, our objection, Lordship, we have filed our objection.
What is this?
On 11/4/2025.
This one, page 92?
100.
Page 100.
Page 100.
What is the order? Verified that the learned rail shall not be influenced by the interim injunction granted by this court on 2/6 and which is extended to the appearance of the party and this is also relegated and appear before the end file an appropriate object. What is this?
So ultimately, this
Where is the injunction status quo?
This honorable court has relegated the matter. Initially, injunction was filed, interim order was passed, and ultimately disposed of this case, Lordship. So relegating the case to the lower court, wherein ultimately the lower court has passed the impugn order, which is the challenge in the appeal, the instant appeal.
Why they are challenging?
They have challenging because the lower court has passed order that in respect of 7 bus that will be remain till 25 of January, and other 1 bus it will be remain till 15 of May. So that's why they have challenging already the earlier 7 bus. Now they are getting already they have executed the contract with the Delhi Public School, and in respect of 1 bus from tomorrow they will again run. Because
my lord,
and Lordship, this case is filed. Lordship, they have ultimately suppressed this honorable court. They have earlier filed a writ petition, case 92, with same prayer.
They have not filed our reply to our objection. Case 92. Because there is an interim order, that's why although we have issued the LOA, but we could not execute the work order in favor of the them. And the same was
No,
intimated.
first of all, Mr. Counsel,
Yes, my
is it your suit?
not my suit.
Then why are you filing all these things here?
But as because as per the contract, I have to provide 10 numbers of buses.
You provide 100 numbers of bus, I'm not concerned. You have a claim against them,
Yes, my lord.
okay?
Yes.
Have you filed a counterclaim before the trial court?
Good, sir.
No. What is this? People will laugh.
No, my lord.
You are in video.
My lord.
People will laugh.
No, my
What has happened to this lawyer? He doesn't know head and tail about law. Absolutely.
No, my lord. My position
No,
is that.
the question does not arise. First and foremost, you are asking that this court, in an interlocutory appeal which is pending, wherein you challenge an order passed by the trial court, thereby granting some relief to the plaintiff,
Yes.
you are challenging that order. That is one aspect. In that thing, you are making a claim against them who is a co-defendant
Here,
again without filing a counterclaim, nothing. And I'm also not saying that you should file a counterclaim. If your claim is there, you have to file a suit against them. What is this?
my position is
And
that.
Lordship, the agreement,
As
the
per
base-
You
the-
have filed
as per
the
agreement,
objection also.
as-
So this is a case of huge cost.
Lordship, and
Yesterday, similar cost has been, the Gujarat High Court has given a good cost of 20 lakhs. We give something
And Lordship, the
21,
court-
make it 21.
so executed, Lordship, during the-
Goodness.
No, not yet.
Mr. Counsel,
Yes,
if you
ma'am.
have anything, go and file a suit against him.
Yes.
Withdraw. Withdraw this type of applications. This is misconceived.
Yes.
And this
Obliged.
affair also has finished.
Obliged.
FAO has no business. Tell me,
Yes.
Then-
Till
because from tomorrow till 14/1/2025, they have been given some injunction as regards one bus, that is the 8th bus.
Yes.
So nothing remains as of now. Fight it out before the trial court.
same,
And here you file a suit.
with same prayer, Lordship, writ petition was filed.
So
That
let
there
us
was
not go into those, isn't it?
Yes.
Even
I
I can, FAO को
kindly
लिखो.
allow me to. do
Mr.
it.
So-and-so, Mr. So-and-so, the learned counsel appearing on behalf of the appellant. And Mr. So-and-so,
Four, that's
yeah,
for four and
Mr.
five.
So-and-so appears on behalf of the appellant. Mr. K. Pulta appears on behalf of the Indian Oil DPS,
Delhi Public.
Delhi Public School. Full stop. The learned counsel appearing on behalf of the appellant submits that taking into account the scope of the order which is being assailed and assailed, he would not like to further proceed with the instant appeal. So taking into account the instant appeal stands closed on withdrawal. Full stop. Mr. So-and-so, the learned counsel submits that there are certain dues which the applicant is entitled from the Delhi Public School. However, that being a dispute between the applicant and the Delhi Public School, the applicant is required, would be well advised to file a suit claiming or suit or other proceedings claiming such directions against the Delhi Public School. He therefore submits that he would not press the instant petition, taking into account the above the instance.
9.
I for what?
That is the visiting right, Lord.
Huh?
Visiting right of his minor. My lord, the matter is your lordship. My lord, I have an instruction to settle the matter amicably, Lord. So 2 weeks time may require.
Who are you?
I am
Wife?
for the respondent wife, Lord. Wife and children's Lord.
Wife and?
Children's Lord.
The children, I'm not concerned. He wants the visitation to meet the children.
Yes, but
So you are, he is the father?
the father.
He is the mother?
Yes.
So why you are not allowing the father to meet?
Lordship, he's always welcome, Lordship, but
Very good.
he
Good.
is not coming to the house, Lordship. But it is not, although it is impossible to send them to his house, Lordship. Regarding this, Lordship, there is a sitting, Lordship, that because the child, the son is also, Lordship, growing up. He is now studying in class 8, Lordship. So
And the
there,
daughter?
daughter class 7, Lordship. So regarding, Lordship, custody of that, Lordship, son, Lordship, because I am not able to control him now, Lordship. So there is a talk between the parties, Lordship, to settle the matter amicably, Lordship. So 2 weeks time they required, Lordship. So in the meantime, Lordship, we will settle it.
The learned counsel is appearing on behalf of both the parties. I acknowledge you. Submits that they are trying their best to settle the matter out of court, taking into account the welfare of the children. Gustav. Therefore, the learned counsels therefore sought for a 2 weeks time in that regard. List the matter on 4th of June, 2025.
Thank you, Lord.
One last matter. Whose matter is there? Oh, your
16 and 17.
matter. Your matter, what has happened? It should have come up top of the list. What happened? Did you find anything?
My lord, I have,
They are a necessary party.
yes, my lord. Make my submission.
Because you have to cut out and say that it is a necessary. And if it is necessary party, matter has to finish. There cannot be a remand also. That is what I think.
I'll make.
When? Yes, yes. Mr. Dekha has been, he's a very busy council.
22nd, perhaps Lordship is taking the High Court matters. Thursday.
Where?
22nd.
These are High Court matters. I have only one day for hearing of civil bench. Today is 13th. Let's try our luck on 20. How many matters are there on 20? My goodness, 18 matters. One thing, we need to finish those. Have it on 20 at the top of the list. 20. Yes, anybody? Anything more?
I pray for a date in item 20, Lordship.
Why?
Lordship, there is a stay on the other side.
What
here
is
for
it?
the response.
CRPIO?
CRPIO, yes.
When?
Lordship, let it be next Tuesday. Next Tuesday.
CRPIO.
Yes.
CRPIO doesn't take much time. Service is complete?
Yes, yes.
Okay, please leave this matter on 16th May 2025 at the admission stage. Admission, it's of a hearing?
It's in hearing.
For hearing at 2 p.m. Liberty given to both the parties to, no, at 2 p.m.
Lordship, Lordship may put in admission.
What is this CRPIO for?
This was against the land grabbing matter. And,
Oh, land grabbing.
land grabbing criminal thing was taken, and against that the appellant had filed and the stay was given. So that's
No, land grabbing can't be done like that. Records are available?
records. I guess it was policy.
Isn't it shown LCR in the course list? Records are in 21, no?
Yes, yes. It's with LCR. Yes.
Okay. I fix it on. You are for whom?
I'm for the respondent.
Okay. Fix it on 17th of June 2025 at 2 p.m.
Obliged.
In time order he is getting, na? The respondent.
No. the
Petitioner have got an
petitioner has
interim.
got
The
it.
interim order passed earlier shall continue. Bill.
Item 19.
What is that? Why? What is that matter? CRPIU? Execution state. Okay, you get it on 16th at 2 p.m.